Item number 29 from supplementary list.
For reasons mentioned in the judgment, this review petition is allowed. The judgment dated 22/2/2018 passed in RSA number 73/2013 is vacated and the said RSA is restored. Registry is directed to list the connected RSA after 2 weeks on a date to be fixed by it for hearing. Item number? Yes.
Appeals were there. One is RFA 42, which is listed today. Another is 41, which has not been listed, madam. From the same judgment, two appeals were there. So both may be taken together, madam, on tomorrow or day after tomorrow.
Not tomorrow. It will again have to come.
Next week, madam.
You have informed the other side. Heard Mr. J. Sharma, learned counsel for the respondent. Also heard Ms. J. Sharma, learned counsel for the appellant. It is submitted at bar that one more regular first appeal bearing RFA number 41/2024 is pending before this court and has arisen out of the same. And in the said appeal, the impugned order is same as that of the present appeal, and both the appeals may be taken up for, and it is submitted that both the appeals may be taken up for hearing together. The prayer is allowed. Registry is directed to list RFA 41/24 along with this appeal on 23rd July. On 23rd July.
My lord, I have filed an IA, my lord. Let it come up on Friday, my lord. Yesterday, this matter, my lord.
You have notified the other side.
My lord.
You want it tomorrow?
Not my lord. Friday.
Okay.
Item number 18. For the second of the
Item number, be louder.
item number 18.
Yes. Why? Have you informed the other side? What is your name? Heard Mr. B. Devri, learned counsel for the appellant, who seeks an adjournment on the ground of personal difficulty. He submits that he has informed learned counsel for the respondents, who does not have any objection to the said prayer. Stop. Hence, the prayer is allowed. Let this matter be listed on 28th of July.
Well, I take the method item number 30 of today's supplementary dismiss. 30. I have filed an IA under order 997. But that action has not been executed.
My lord, the IA may be called for. I am appearing for the petitioner. The thing, he was not appearing, so an order of expertise is there. So he has filed an IA and it has not been listed. So Lordship may call it simple. My lord, if Lordship vacates that order, then your Lordship will hear these things, my lord. Because of the non-appearance of these, my lord, applicants, the matter has been delayed since September, October, my lord. So let
the IA be called for.
And Lordship will take it up after some time.
Not sometime, in regular course. As per list, we will take it up.
Yes, my lord, before hearings. My lord.
In the admission call. In the seriatim, we will go.
This is the only admission matter. Supplementary admission. After orders, Lordship will take.
At 2. At 2, we will take it up. At 2. Okay.
May it please your lordship. Lordship, I beg to mention item number 25, lordship. Lordship, I am for the appellant and consent has been taken from the respondent side, Lordship.
For what?
Lordship, the matter may be adjourned, Lordship, because due to some personal difficulty, my the conducting counsel is unable to appear, Lordship.
You are for?
Appellant, Lordship.
Heard Mr. S.A. Singh, learned counsel for the appellant, who seeks an adjournment on the ground of personal difficulty. He submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who does not have any objection to the said prayer. Hence, the same is allowed. Let this matter be listed.
Lordship.
There is a similar matter with this matter, Your Honor. It's RFA 22/23. That may be listed together.
28 July.
28 July. It is submitted at bar that similar means arising out of same.
Not same.
But at the same.
No, no.
Appellant is same.
Appellant may be same. How it is connected with this matter?
Same building, Your Honor. It's about the demolition of the building. Same building has been demolished and they are the occupant, Your Honor.
What is your name?
And Rahman.
Miss N. Rahman, learned counsel for your respondent in RFA number. In the present case also you are for the learned counsel for the respondent. Your government advocate, learned counsel for the respondent, submits that another connected regular first appeal where the appellant are same and matters are also similar may be tagged with this appeal. The prayer is allowed. Registry is directed to list RFA number. What is 22/23 along with this appeal on the next day fixed. Did they say? Let this matter be listed on 28th of July.
Obliged, Lordship.
May please, Your Lordship. Lordship, with the other side concern, I beg to mention item number 23 for adjournment, Lordship.
Why?
Personal difficulties.
Heard Mr.
Yes, Pegu.
S. Pegu, learned counsel for the appellant.
Appellant, Lord.
I am for respond.
Learned counsel for the appellant who seeks an adjournment on the ground of personal difficulty. Also heard Miss, what is her name?
E. Devi.
E. Devi, learned counsel for the respondent who does not raise any objection to the prayer. Hence, the prayer is allowed. Let this matter be listed on 30 July.
One more prayer, Lordship. Lordship, item number, I beg to mention item number 26, RFA 57/25. I am praying for adjournment, Lordship. Last occasion, I have already submitted, Lordship. They are amicably try to settlement, Lordship.
You have informed the other side.
Lordship.
Have you informed the other side?
Yes, Lordship.
Heard Mr. S. Pegu, learned counsel for the appellant who seeks an adjournment on the ground of personal difficulty. He also submits that there is a possibility of an amicable settlement between the parties. He has also submitted that he has informed learned counsel for the other side regarding his prayer for adjournment. Hence, the prayer is allowed. Let this matter be listed on 30 July.
Obliged.
I beg to mention listing of 3 MFA in the order column for next week.
11th May.
My lord, similar prayer for my lord, the listing of a MSc appeal, my lord, on the next week, any date, my lord,
11.
a hearing.
No.
Next week,
It will come in orders column.
my lord, then I will,
You pray before registry.
my lord, for hearing, my lord. Obliged.
May I please, Your Lordship? Lordship, I beg to mention for listing I civil
Last was 20 May 2025, orders column fuel.
11th May. Yes, Mr.
Is a partner personal difficulty, then Mr. Allah has a right, okay, but we declare. This will be taken on later.
All the part-hard matter, my lord, it is. So if any personal difficulty there may be taken day after tomorrow, my lord, Thursday. And almost he has completed his part, my lord. I have to reply.
Next কেতিয়া পাৰি পাৰ্থৰ মেটাৰ অলপ আগত দিলে হ'ব 21 May.
21 May. আর আগত নহব। Huh?
Heard Mr. S.P. Roy, learned counsel for the petitioner. Also heard Mr. J. Sharma, learned counsel for the petitioner seeks an adjournment on the ground of some personal difficulty. Considering the grounds, the prayer is allowed. Let this matter be listed on 21 May.
My lord, in one case, I just mentioned item 22. Date was given on 23rd of July, I think. Maybe on the first week of August, my lord. And 23rd July may not be available, lord.
6th August.
Item 1.
May I please the motion? This is the second case application to lottery. Here lottery, the ECR was called for. Lottery will kindly see that I was arrested lottery on 26/3/2025. Trial is going on, already 7 witnesses been examined. The lottery will kindly find the cross-examination of the informed here. I'd like to say lottery. Comments cross-examination from lottery Zukindi. Lottery will find that there are blatant disregard to the NDPS Act itself. And the seizure of the contraband itself is doubtful. It's coming from page 53, Lordship, they can tell you.
No, what is the date of your arrest?
Date of arrest, Lordship will kindly on 26/3/25.
But lordship, out of 8 witnesses, 7 has already been over, lordship. It is at the fake end of the trial, lordship.
That is true, Lordship, but now Lordship will kindly see.
What is your ground?
Yes. Will kindly see that now a new court has been designated as an NDPS, special NDPS court. And all the cases are being transferred there. The next bit has been waiting for production. Thereafter, the case for the evidence will be fixed. Lordship, I kindly see that recently there was a bereavement in my home. The Lordship was pleased to allow me some interim bail for that.
No, if the trial takes time, if there is prolonged incarceration, then on that ground you will get bail after 1.5 years. Wait for 6 more months.
Within 6 months, lordship, already 7 has gone, lordship. 7 witness has been examined within 6 or 7 months.
No, because of the embargo of section 37, how will you overcome that embargo? That aspect we will not go into now. Before trial, we will not conduct trial. Let the trial court. How many days? One year? 1 year, 2 months. Not 2 months.
75, 78 days. As on today.
Because on the ground of prolonged incarceration, you will not get bail before 1 year, 6 months. So you withdraw it and file again after. No, bail applications cannot be kept pending.
difficult and filing will be difficult in our part because nobody from his family is coming forward. Because of the present bereavement, he is in custody. He will be facing difficulty in filing a fresh application. It's a very fair certificate.
July 13.
It's in the month of June, Lordship. I think by that time,
The-
information of the IO will be final.
Okay. On request of learned counsel for the petitioner,
First week of-
let this matter be listed on 22nd June.
Can it be? First week?
16th of June.
Orders, item two.
That will be. Try for the petitioner limit.
May please Lordship, last time I took some submission that somebody is deputed for respondent number one. So, but not filed it. I do not know file. So I got the information from the company.
You have submitted your wakalatnama.
That is the thing. So last
You,
time.
you file
No,
wakalatnama.
no. That is last time this court order. So I took some information from the company. So I appeared. So when I contact with the company, they said that there somebody is appears.
Who is that somebody?
That is not true.
Why?
So.
He may be some of
panel-
your colleague only.
Might be.
So if we,
I think I have very amicably.
Delay only for 6 days only, Lordship. So Lordship anything else, but
So that I have no right to say anything.
then we'll proceed ex parte against the, if,
I have no submission here. Because it is my, unless.
heard Mr. A.R. Agarwal, learned counsel for the applicant. Also heard Mr. R.C. Pal, who submits that he has been informed by the respondent number one insurance company that some other counsel has been engaged by the respondent number one to appear in this case. However, none has appeared. As regards other respondents, stop. It appears from the office note dated 2/5/2026 that notice issued to respondent number 3 has been duly served. However, the service report in respect of respondent number 2 is still awaited. The registry is directed to place the postal track consignment report of notice issued to respondent number 2 before this court on the next date fixed. No, short date, May 2nd week.
6 day delay.
Huh. Let this matter be listed on. Should we dismiss the?
He said that for enhancement, that is.
Okay, we wait for service
Yes,
report.
I know.
Let this matter be listed again on 15th of May. If by 15th of May respondent number 1 is not represented, we may proceed ex parte against.
Item four.
These are Lordship. Lordship, as per office law dated 29/4/26, answer notice in respect of respondent number 5 entered with illegible signature. And visa ID card no answer notice or service respect of respondent number 1, 4, and 6.
What is to be done? More.
5, we take fresh steps.
Heard Miss M. Sakya, learned counsel for the applicant. On perusal of the office note dated 29/4/2026, it appears that notice issued to respondent number 5 has returned without service, whereas service report in respect of respondent number 1, 4, what happened to 2 and 3? 1, 4 and 6 is awaited. Stop. The registry is directed to place postal track consignment report of notices issued to respondent number 1, 4 and 6 before this court on the next date fixed. The applicant is also directed to take fresh steps for issuance of notice upon respondent number 5 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of June.
Item 5.
As per office note, dated 29/4/26. Unsubmitted notice, respondent number 3 and 4. And respondent number 1 and 2 has arrived as CIP also. Sometime maybe a waited for respondent number 1 and 2.
But Mr. S. Fegu, on perusal of the office note dated 29/4/2026, it appears that notice issued to respondent number 1 and 2 have not yet returned, whereas the notice issued to respondent number 3 and 4 have returned without due service. In view of above facts, the registry is directed to place the postal track consignment report of notices issued to respondent number 1 and 2 before this court on the next date fixed. The applicant is directed to take fresh steps for issuance of notice upon respondent number 3 and 4 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of May 18, not 18th May, 28th May.
Item 32 from supplementary list.
It's a clear line. No, लोक अदालत
अच्छा।
आपका client is any
ठीक है, ठीक है।
the phone number to them.
Oh, ठीक है।
Lakship, I mentioned it yesterday. The claimant, Lakship approached, in fact, the insurance company also that they want to fix it for no.
Miss Adi Majumdar, learned counsel for the appellant. Also heard Mr. What is your name? Mr. Burua.
S. Sakya, my lord.
S. Sakya, learned counsel for respondent number 1,
1, my lord.
claimant.
Claimant.
It is submitted at bar that there is a possibility of an amicable settlement between the parties, and therefore a request has been made to refer this case to Lok Adalat, ensuing Lok Adalat on 9th of May 2026. The prayer is allowed. Release this matter before the Lok Adalat on 9/5/2026.
Item 33. Item number 33.
None has appeared for any of the parties. List this matter in the next week on a date to be fixed by registry.
Item 34.
This IA has been filed for substitution of legal witness. Well, this case was already settled in the last Lok Adalat. After the settlement, according to him, the claimant is died. So they want to substitute the legal years of the deceased. So I have no objection because already settled. My lord,
The MAC appeal has been disposed of.
yes, dispose of my lord, page number.
Then how there can be a substitution?
Lordship, actually, after the dispose of this matter, the appellant has expired without receiving the awarded compensation.
No, they will give the awarded compensation to the legal heirs.
That is why linear this,
But substitution is not required.
otherwise how can this court will identify that they are the legal heirs? That is their file.
Then before that, you have to restore the MAC. MAC appeal has been disposed of.
Dispose of, my lord, by way
Without-
of settlement.
Without restoring it, how there can be substitution in a disposed of matter?
Exactly right, my lord. This is the procedure. Lordship, another guy is also that to release the compensation amount. Actually, Lordship, the legal representative has approached the state for receiving the awarded compensation. But that is that the certificate necessary. That is why this able
Oh, who say?
registry. It has been- Already we have deposited the amount.
You file an IA
Then
for releasing the amount to the legal heirs without substitution is not
yes,
necessary.
that is the substitution is not necessary. If you go for substitution, but a long process is required. Only for releasing IA because of
Heard, Mister, what is your name?
MDECA.
M. Deka, learned counsel for the applicants. Also heard Mr. R.C. Paul, learned,
That's for number three.
learned counsel for respondent number 3, insurance company.
My lord.
It is submitted at bar that the connected MAC appeal number 631/2018 was disposed of in, where is the order?
My lord, page 10. Page 10. It will dispose on 14/9/24. The amount has been. From 9, page number 9, a relevant page is 10.
Disposed of in the Lok Adalat, which was held on 14 September 2024.
My lord.
What was the agreed amount?
And the additional amount is 30,000, my lord. Initially, they have deposited 19,500. 685.
That you have received.
That is a bank. Line before the MSC, MSCT preload.
It is submitted at bar that both the parties, that initially the respondent number 3 insurance company had deposited an amount of rupees 19,685 against compensation payable to the claimant before the Motor Accident Claims Tribunal number 3, Kamrup Metro, Gauhati. It is further submitted that in the Lok Adalat, the insurance company agreed to pay an additional amount of rupees 30,000. So it is further submitted that further submitted by learned counsel for the petitioner that after passing of the said order in the Lok Adalat, the claimant, namely, what is the name?
June.
June Boro had expired on when he expired? 14/11/2024, without receiving the compensation amount in pursuant to the orders passed in Lok Adalat. It is further submitted that as the present applicants, namely Umesh, who are you?
Why?
Namely, Komali Boro is the widow of the original claimant June Boro, and she is entitled to get the compensation amount awarded to her deceased husband. Hence, this application for substitution has been filed. Stop. Mr. R.C. Paul, learned counsel for the insurance company, submits that the insurance company does not have any objection to release the amount to the legal heirs of the deceased claimant, namely
With
Srimati Komali Boro.
With proper identity.
Stop. It appears that since the connected MSC case has been already disposed of, the question of substitution at this stage does not arise. However, where is that 30,000 Where?
Before the registration, this
and 19,000?
19,000 MSCT number 3 loan.
However, the registry of this court is hereby directed to release the amount of rupees 30,000 deposited by the insurance company in pursuant to the order dated 14/9/2024 to the present applicant, namely Komali Boro, who is the legal heir of the deceased claimant, after proper verification. Similarly, the Motor Accident Claims Tribunal number 3 is also directed to release the amount of rupees 19,685, which has been deposited by the insurance company in connection with MSC case number 1701 of 2009 to the present applicant, namely Komali Boro, who is the legal heir of deceased claimant, namely June Boro, after proper verification. With above observation, this interlocutory application is disposed of.
Actually, in the appeal, the applicant's name, that is the husband of the applicant, name was recorded as June Boro instead of Sanu Boro. That was
Alias.
submitted by way of applicant. That is at page 19.
Actual name is Janu Boro.
June Boro alias Janu Boro. June Boro Jojot likise alias Janu Boro.
No, no.
And his father was also recorded.
Within bracket, son of late Sumeshwar Boro.
That should have been Moneshwar Boro.
Now father name kati dio.
No, like.
This much would
Well, I think
will be enough.
he's satisfied, I think.
With above observation, this interlocutory application is disposed.
Much of it.
Item 45. For the first time, it is for condemnation.
Mr. S.P. Sharma, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been filed by the applicant insurance company, praying for condonation of delay of how many days? 267 days in preferring the connected miscellaneous first appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of June.
Hearing, item 7.
May I please your Lord? The Lordship has heard the matter in part.
Yes.
The other day.
Who is for the other side?
Mr. Paul for the insurance company.
R.C. Paul, he was there.
The last occasion he has prayed for time, placed before this honorable court, judgments passed wherein contributory negligence could be attributed to the claim. Here in this case, 50% of the awarded amount has been deducted on the ground of contributory negligence.
Yes, Mr. Paul.
Yes, madam. But I have gone through the record, but I need to the cross-examination because there is very illegible. So I have to go through it because there is a 3 witnesses.
No, you should have gone through
Yes,
because it was earlier listed on 4th of.
yes, your lordship.
Now, what is your prayer? You want to?
Little time because I will go through. I have gone through many things, but I cannot read properly. That is why it fixed on the.
I'll wait here.
Okay. Okay, go through.
at
We
2
will
p.m.
take up other matters
At 2 p.m. if it is possible.
in the second half. Okay.
Madam.
Item 8.
Lordship heard it last time. That day I had something. Lordship heard both the sides that day. Lordship wanted to know the judgment of Polar and Nickel.
Judgment of?
Polar and the person. Submitted, they are in a response. I have submitted the judgment.
Citations. Brief gist you can tell. Briefly.
Appeal filed. The grounds that in this case, Lordship, should I read the judgment or I?
No.
Lordship, in this case, in WC cases, Lordship, when there is a injury and it is not non-scheduled injury, the requirement is that a medical practitioner should give evidence about the disability as well as loss of earning capacity. In this particular case, that was not done. And the commissioner himself assessed the loss of earning capacity. That he cannot do. That is why my submission was that the case will be a case of remand, so that the commissioner allows the doctor, allows the claimant to be assessed by a medical practitioner and then comes to a judgment. The commissioner doesn't have any right under the Act of Lordship to assess the loss of earning.
Price compensation act. Okay.
May please inform. But the question which has been raised by Vladimir is already decided by our court on the 25th.
No, Mr. Bhattacharya, let her
Ah.
complete.
If it helps me, then it
It
was remanded back.
No, dismissed. He said-
Which one?
This is the case of National Insurance Company Leeladhar Chaudhary. It was decided on 6 January 2025. I am going to be giving a copy to you, Lordship. So every aspect of her commission was discussed here.
And it says, no, you have not appeared, it's some other advocate, Aswad, Mrs. Aswad. She raised the same question as your, as my counter, same question he has raised, that
Non-scheduled.
that non-schedule and commissioner doesn't have the power to assess the
Then
loss.
this case has to go to a larger bench because already our high court judgments are there in that partnership. Oriental versus Mohammed Farid Ali as well as Oriental versus.
All was discussed in this case, my lord. All was discussed. And I also forward, my lord, I cannot make submissions because of my health, my lord. I'll give a decision of the Bombay High Court
No.
on the same matter.
Okay, we'll come to you. Let her come back.
The commissioner does not have the power to, our own high court as well as our high court
Now, what is the statutory provision?
statutory provision, lordship, it has to be qualified medical practitioner.
Which is the provision?
4C.
41C.
41C.
One is there, lordship.
C2.
Yes. In the case of an injury not specified in Schedule 1, such percentage of the compensation payable in the case of permanent total disablement as is proportionate to the loss of earning capacity as assessed by a qualified medical practitioner permanently caused by the injury.
So this you are relying that
Yeah.
the assessment has to be loss of earning capacity also has to be assessed by qualified medical practitioner.
That's why it is perverse. We have said that the judgment is perverse because it has not followed what is the requirement of law. And qualified medical practitioner is given at lordship definition is at section 2I. Qualified medical practitioner means any person registered under any central act, provisional act, or an act of legislature of a state providing for the maintenance of a registry.
Instant case, he was not examined.
They said he was dead, but they have not given any document. They have not exhibited any document that he's dead. But then it was incumbent, if he was dead, suppose lordship, it was incumbent upon the commissioner because this is basically a.
Who is that?
Okay.
Who is the claimant here?
He's a walker, my God. He's a walker.
No, whether he died in the accident later on.
The doctor died. They said the doctor died, but they have not given any document that the doctor died. In argument only, they submitted that the doctor died. And if the doctor had died, lordship, then it was incumbent upon them because they have to prove their case. Last time they gave a judgment of our high court that was in that they have mentioned one A.J. Thomas case, lordship, that was in relation to MSc appeal, first of all, and then lordship, this A.J. Thomas case, lordship, that review petition was filed, that they have not mentioned on the last day. A review petition was filed and the case was remanded back to the tribunal. And that was in the MSc case, not WC, lordship. It is whatever is to be done in WC, because here, lordship, in MSc cases, there is no substantial question of law. But in WC, there is substantial question of law has to be there. And the requirement of law in the act has to be followed totally by the commissioner, lordship. That is what is our submission, lordship.
Which judgment you are relying?
I submitted, they are there.
Yes, it is there.
Then one is lordship MFA 43 of 2011. Oriental Insurance versus Puradati.
Yes.
In this lordship, the relevant paragraph will be 11 and 12 lordship. And 13 because of the remand. In the judgment reported in 2009, 1 GLT 138, this court held that commissioner awarding compensation on the basis of the certificate of claimant's physical disability cannot be a substitute for loss of earning capacity. The said decision, while discussing section 41C2, held that the medical practitioner has to determine the percentage of loss of earning capacity.
Which para you are reading?
11 loss.
Okay. Yes, please.
Earning capacity, that will be line 4 lordship I have taken.
Yes, yes.
Earning capacity in case of different injuries not specified in schedule 1. Similarly, in the decision reported in 2009 ACJ 807, this court supported the view that the evidence of medical witness is a condition precedent, this is vital, condition precedent for assessment of the disability of the injured person so as to enable him to claim the compensation under the Act. This is a case wherein the injuries referred are not specified in Schedule 1 of the Act. Under such circumstances, a duty was cast upon the learned commissioner to assess the loss of earning on the basis of evidence of a qualified medical practitioner. So we are harping on this lordship. When they say he was dead lordship, the commissioner was duty bound as per the Act itself to get the assessment done through a medical practitioner. Instead, the learned commissioner on his own, without taking assistance of qualified medical practitioner, assessed the loss of income of the assessment of the award and accordingly failed to apply the jurisdiction as stipulated under the provision of the law as clearly above stated. Accordingly, the subsequent question of law is decided in favor of appellant of the appellant. On the submission of learned counsel on behalf of the appellant, the subsequent question number has not been discussed, which has become redundant after judgment of Amiruddin. Amiruddin judgment lordship is relating to income lordship. Then in keeping in view the discussions herein made, I hereby set aside the award impugned herein. This appeal passed in case number WBC 45 so and so, government dated so and remand the same to pass a judgment afresh, keeping in view the observation made in this judgment. So lordship, and then on similar lines, our own High Court lordship. Earlier judgment lordship, one judgment lordship, this is far more earlier, that the commissioner doesn't have any right to assess the loss of earning capacity, is lordship New India Assurance versus Sanjeev Kumar.
Para 4. That
Yes, exactly, para 4. The Workmen Compensation Act provides the mode and method to determine the compensation. The court cannot adopt some mode or method which is not provided in the Act. In the portion of the award posted above, the court determined the percentage of loss of earning capacity at 50%. That power, this is important, that power is not available with the commissioner. So this award shall stand quashed and the matter shall go back to the commissioner to assess the compensation afresh. And in order to do that, he may even ask the doctor to appear before him and give his opinion with regard to percentage of loss of earning capacity, which we are also submitting lordship in this case.
whether on this point any apex court judgment is there?
Apex. Huh? Apex court judgment lordship. Right now, I do not have I can search because our High Court itself gave Vimalnath judgment is also there on that. Vimalnath judgment lordship discusses about 2I, 2G, that loss of money. And lordship, our own High Court, MFA 186 of 2017, Rupchan Ali lordship. Here also, same thing, it was remanded back. Oriental Insurance versus Rupchan Ali. MFA 186.
So your contention is that commissioner does not have that power.
That is the only issue.
Yes.
Okay.
Commissioner, because as per the Act itself, and as per unlike MSC cases, lordship, in WC cases, the commissioner has to follow and And another ground we had taken, Lordship, whether in view of the fact that the injuries suffered by the petitioner does not fall under Schedule 1 injuries of EC Act, the compensation can be granted under Section 4B of the EC Act. But Lordship, if the commissioner does not have the right to pass a loss of earning capacity, Lordship, that's why we had mentioned, Lordship, I'll just read 4B, Lordship, where permanent total disablement results from the injury, an amount equivalent to 60% of the monthly wages of the injured multiplied by the billing factor. This is what the court has done, Lordship. But Lordship, the commissioner does not have any, it is perverse because the commissioner has acted beyond its jurisdiction. That is my submission. And I'll give any reply, Lordship, if necessary.
Yes, Mr.
Well, not the only the law points which she has submitted. It has been decided that the decision of our High Court by Justice Robin Foucault, it is given there, my lord, in the judgment. That entire issue was decided, my lord, discussed, my lord. That is, your lordship will find in the paragraph 14 to onwards, my lord. It will 2000. MFA 48 of 2006, disposed on 6 January 25. Your lordship will find me in paragraph 18.
Para 18.
18 onwards, my lord. In the aforesaid decision, the Honorable Supreme Court held that the doctor who treated the injured claimant or who examined subsequently to assess the extent of his permanent disability and only in respect of the extent of the permanent disability, the loss of earning capacity is something that will have to be assessed by the learned tribunal with reference to the evidence in the entirety. 18, then 19, my lord.
We know which Supreme Court decision it is referring to.
Discuss, my lord. I will give.
No,
Your paragraph 19.
that was in respect of a case under motor vehicles.
My lord, that has been also discussed here, my lord. The lordship will come into paragraph 19.
Yes.
Now we summarize the principle discussed above. All the injuries permanent disabled. Percentage of this is there. Your lordship 3, my lord. The doctor who treated the injury claimant.
Where are you reading?
My lord, page
Para 19.
Para 19, my lord, surplus 3. The issue. The doctor who treated the injured claimant or who examined.
No, which para of the judgment?
Para 19 of the judgment, my lord.
It is a fact. It starts from.
No. We may summarize the principle discussed above.
In
That
para
is-
19.
Yes, paragraph. Page 23, my lord. Your lordship.
Page 23 of the.
Judgment, my lord. 23, last. Para 19. Your lordship, our High Court judgment, we are ready, your lordship. That is a National Insurance Company versus Lakhadar Chaudhary.
Yes.
19, my lord. 19 surplus 3. A doctor who treated the injured claimant or who examined him subsequently to assess the
This is a okay under work.
This
was also a case under workmen's compensation.
Here also the motor vehicle and it is also said since it is a social justice, so Motor Vehicle Act also will come into this, my lord. He has discussed in interview with the Supreme Court decision. Then, my lord, that is paragraph 3. Then, my lord, your lordship will come. Paragraph 22, my lord. My entire question is, my lord, whether the learned commissioner has the power to assess the employment loss, my lord, earning capacity.
So
He says that no, it is only the commissioner has the power, not the doctor. He can only assess disability. This is the one, my lord. He is cited here, the Supreme Court decision also.
I am also of that view, but the earlier judgment of this court
Yes, my lord. Then
have specifically held that
yes.
it is beyond
Then, my lord, I will
the provisions of statute.
I will say that, my lord, here another judgment. the Nagpur, as well as Madras and Bombay, all they do say is that commissioner is the competent.
No, we will not go Nagpur.
Well, there is a Supreme Court citation was discussed, pros and cons, my lord.
No, if there are conflicting judgment of this High Court on the same issues,
So
it has to be
yes, your lordship will
put to rest by a higher.
your lordship will do so if it feels so. But after going through this judgment of Bombay and Madras and Jammu and Kashmir, it is crystal clear, my lord. Because their Supreme Court decisions were cited.
Bombay is
This is Bombay Nagpur branch.
page number,
Page number,
para.
my lord, paragraph 15 onwards. 141C. Your lordship will see that it is the contention of the learned counsel for the appellant that the examination of the medical officer is indispensable for determining the hours of learning capacity of the injured employee. It is difficult to assess to this contention. The competence of the commissioner of the labor and the medical practice are different and independent. So he has discussed all these issues, my lord, herein. And
No, in the judgment of MFA 48/2006,
yes, my lord.
what was ultimately held?
Ultimately, insurance, this is the commissioner is the person,
Where?
last paragraph, my lord, of the judgment. And award was given.
Which para?
Hmm.
Which para says that?
Since the loss, yeah, I have, that is the paragraph 21 of the judgment. I have carefully gone through the decisions of the coordinate branch of this court. The lordship got it, my lord.
Huh.
So referred by Mrs. Roy, the learned counsel for the appellant, and in view of the decision of the Supreme Court, and in the discussion referred therein, I am of the respectful disagreement with Ms. Singh.
Okay.
Notable-
But the Supreme Court judgment was in respect of a motor vehicles accident
Yes,
case.
and he has stated that this is,
But
since it is a social.
relying on that judgment,
Yes, he
the
says, since,
court has disagreed with the.
says this, since this is a social legislation, so this is part of it.
Okay, I'll go through the judgment.
Yes, Your Honor. Then your lordship will.
Likelihood it may be referred to a higher bench.
Maybe, my lord, your that I leave to your lordship will do. I'm not saying. But, my lord, I have given this much.
No, even if there are two
No,
two
your
judgments
lordship.
of
that is,
same
that-
High Court,
About the.
it has to be referred.
That's it then. The Bombay High Court is.
Still, I'll go through.
Yes, my lord. I have
Sure.
given the judgment of. I have given the judgment.
Disagreement, lordship, when on that judgment on 48, lordship, I would like to say when the court disagreed, that court itself should have mentioned it for a higher bench. The court did not have the right to pass a judgment, the 48 judgment.
Court relied upon the apex court judgment, motor vehicles. Now whether.
If the court disagreed with the other judgment, it should have been referred to another.
In light of the prononciatis ruling.
Dawoodipura, lordship. Dawoodipura, very clear.
Okay.
Dawoodipura is.
I will go through this aspect.
My lord, your lordship will also go through the judgment of the Madras High Court. It is a voluminous one. I have given web copy. My lord, all the relevant, everything was discussed there.
Which para?
My lord, your lordship will go from for 9, 10 onwards, my lord. 11. Supreme Court was also discussed therein, my lord.
Okay, I'll go through it.
That is note, your lordship will note the paragraphs, my lord. 15, my lord, and 19, 20 paragraph of the 21. That is the core issue that has been discussed with the in relation with the Supreme Court also. That about the examination of the doctor and the assessment by the commissioner. this is of the Bombay, this is Madras.
MAC case,
No,
Lordship,
just a minute,
Rajkumar
just a minute.
Ajay Kumar is very clear.
Yes, yes, yes.
Produce evidence for disability. In our, this particular case, Lordship, in 48, 2006, I do not know, but in Rajkumar Ajay, MAC cases also, doctor has to assess the result. In our case, Lordship, doctor did not appear.
With the
There is a
certificate,
distinction between that.
but the judgment clearly says, my lord, the certificate was given by the board, doctor was dead. And if they never raised any objection during the
Okay.
cross also, and yes, and
Given by doctor.
no, give me the petition, the judgment of the MS. The petition to claim.
Okay, I'll go. I have on facts, I have already heard you on.
And your lordship will also go to the Bombay, I have given one Bombay High Court, my lord. No, Bombay and Kashmir. Delhi. Bombay and Kashmir, my lord. All the issues are discussed, my lord. The point she raised here.
Other
In-
high courts
just-
don't matter,
either-
Lordship. Our high court, when there is a judgment, and in that it is mentioned that I do not agree. That itself amounts that we should go to a larger.
That is the point of.
Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. K. Bhattacharjee, learned counsel appearing for the respondent. Hearing concluded, judgment reserved.
My lord, I'd like to mention item number 24, my lord. I have already taken the consent from other side. Can
Twen-
you defer for any other day, my lord?
20,
Oh, 20? 24.
24, heard Mr. K. Bhattacharjee, learned counsel for the appellant who seeks an adjournment on the ground of personal difficulty. He submits that he has informed learned counsel for the other side regarding his prayer for adjournment, and who does not have any objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry. Noting 9.
Item 9.
Mr. Paul, you are ready with parted matter.
This is 9 is my last 2-3 occasions when is my called for, but not
Nine.
appeals. So last time also my that is for the interest of justice 2 days fixed for passing the final order by this. They have challenged the judgment and award of the, we have already complied with it. Not
You
yet.
have paid.
We have paid it along with interest. That is why we have not filed this.
None has appeared for the appellant on.
Kindly one thing, because this appeal itself is not a maintenance.
We are dismissing it for default.
And if default, he will come again for restoration.
But
Because
now we
it
cannot
is a
go
case
into.
of 2016.
But we cannot go into any other question
Yes, otherwise.
except dismissing it on default.
To mention, my this earlier occasion did not appear.
Heard Miss,
Case
no,
of 10 years.
none has appeared for the appellant on call. Mr. R.C. Paul, learned counsel for respondent number 3 is present. On perusal of the records, it appears that on earlier occasion also, that is on 7/4/2026 and 11/2/2026, 6/11/2024, none has appeared when the matter was called. It appears that the appellant is not interested in pursuing this matter. Accordingly, this appeal is dismissed for default.
Item 10.
There is a cross objection also.
This is cross.
What is it?
Mainly filed at two grounds. One is that lordship, this is of a government employee. And therefore, the age of the deceased ought to have been determined on the basis of some service record or some additional qualification. It was determined on the basis of taken as per post-mortem. But, but subsequently, lordship, he has today lordship brought some documents.
Kindly see the last order, Lordship. We have been directed to produce the original pension documents. So as to ascertain the age of the.
Which order?
Last order, Lordship.
No, in appeal, how we can go into other materials without bringing the same on record under order 41 rule 27.
Lordship, that is it. Order, there is an order by the Supreme Court.
Okay.
That is that.
Okay.
We have been asked, directed to produce the original. I am producing the same. Pension documents. Xerox to later.
You have photocopy?
I have a photocopy of.
No, you give photocopy to the court.
I have also photocopy of the admit card also, same date.
What is the
Pension.
date?
Date is 13/2/76.
Which column?
Page 2, Lordship. 5th column. It is not clear, I think, Lordship. It is,
Nothing is legible.
Lordship, I can see the original. Thirteen to 76.
Yep, ready. Well, then going by this date, what would be your age? His age?
It's
And-
37 years at the time of
And-
date.
And what was assessed in the postmortem examination report?
It is also 37 years. And moreover, I have an admit card, Xerox copy.
Okay,
It
what is
also
your
mentioned-
another ground? This ground does not.
This ground he has taken.
Yes.
The other ground lordship is very simple ground lordship. This conventional heads of compensation lordship. In this case, altogether 4,25,000 have been awarded. In this case. Loss of consortium, this has been standardized in the city. 40,000 for loss of consortium. Even loss of estate, 1 lakh is plus 15,000. Funeral expenses, 25,000. That also should have been 15,000. So this loss may come to page 21 of the
21 of the
memo of judgment, page 15.
yes.
Loss of consortium, that should be loss of 40.
Instead of 1 lakh. Okay.
Loss of love and affection, care, the minor children, that is taken at 1 lakh each loss. Even if Constitution does not allow lordship, has not made any mention for children, even if it is allowed subsequent by, for subsequent judgment in Nanu Ram, etc. Then even at that also it can be 40,000 per head. That's it. And loss of estate is very less, no, dispute about it. It will be getting down. And funeral is 52. In Pronacity, all these heads add up to 70,000. Maybe 10% can be added. So, with
So
that,
you are only challenging the quantum,
it's quantum, because that ground is lost. He has produced the proof unsatisfied.
loss of estate.
Loss of estate, loss of love and affection. And that, let me see, also if there are any other grounds. I'll come to some other.
Pronacety's judgment is there with you.
Yes.
Para?
There are 52. And taking into consideration that earlier 1 lakh used to be awarded. So that has been brought up.
In which para?
Para 52 lots.
No, not in para 52.
In that case, we have a, it is 51 in the, here I have the FCC citation also, it's 52. Maybe there is 1 or 2 paras here and there.
Mm. 54,
54 in the case. Right.
15, 40, 15. When the accident occurred in this case?
13 lots.
Yes, Mr. Burman. Talukdar,
Lordship, so far as age is concerned, there is no dispute,
no dispute.
Lordship. And so far as conventional amount is concerned, the Nane Tribunal relied upon earlier judgments. And at that time, the judgment of constitutional bench was not in existence. Prior to that, there are several judgments, and relying upon that judgments.
No, yes, the decision was passed before Pronacity.
Lordship,
It is still applied also. It has
No.
been applied in all.
No, the decision was passed before Pronacities.
But Joseph, this question has arisen in another court under it. Joseph, I had produced a judgment, in this case, I'll produce a judgment. That this will apply to even cases which are pending at that point of time.
Not pending, which were decided before Pronacity. Pronacity will not be applicable.
The appeal is a continuous suit process. If it is pending in a bill, we consider as a continuous suit process. I remember giving a judgment.
You produce that judgment. That whether Pronacity will be applicable to
Yes.
those cases which were decided before.
It's very important. It should be allowed.
When will you produce?
no, Lordship, next week, Lordship. Lordship,
Next step.
original pencil papers with me for last 6 months.
No, you return it back.
No,
There.
we'll return.
Heard
Uh,
Mr.
Next week, Lordship.
Yes, next week. R. Goswami, learned counsel for the appellant. Also heard Mr. No, in cross objection,
Lordship, there is a point, Lordship.
or we'll hear the
Lordship.
cross objection, let him bring the judgment.
Lordship. So prohibition is only one ground, that is loss of dependency, Lordship. There are 4 dependents. But learned tribunal came to the finding that it is settled law that when father is there, mother will not be dependent on the son. But it is settled position of law that mother is always dependent on son.
So mother was not considered as the. Okay, we'll. Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. M. Talukdar, learned counsel for the respondent. In this appeal, the main contention of the appellant are twofolds. Firstly, that the age of the deceased in the instant case was assessed on the basis of post-mortem examination report, where his age was assessed to be of 37 years. It is submitted by learned counsel for the appellant that since the deceased was a government servant, some official document must have been there reflecting the age of the deceased, and the same ought to have been produced before the Motor Accident Claims Tribunal. It also appears that by order dated 4/2/2026, a coordinate bench of this court had directed the respondents to produce the original pension book in this regard. Today, Mr. M. Talukdar has produced the original pension book, on perusal of which it appears that the age of the deceased reflected in the pension
Date of birth is
payment order is the date of birth of the deceased mentioned in the pension payment order is 13/2/201976,
1976.
which makes the age of the deceased at the time of his death to be 37 years. Considering this, learned counsel for the appellant submits that he is not pressing the said point. However, he submits that the second contention of the claimant, that the compensation awarded against the conventional head of loss of consortium and loss of estate were assessed on a higher side at rupees 1 lakh each by the tribunal, which is contrary to the guidelines laid down by the apex court in the case of National Insurance Company Limited versus Pranay Sethi, reported in 2017-16 SCC 680. So upon this, learned counsel for the respondent submits that in the instant case, the impugned judgment was passed by the trial court before the passing of judgment by the apex court in the case of Pranay Sethi, and therefore the ratio of and he submits that the ratio of the judgment in Pranay Sethi will not be retrospectively applicable to those cases which have already been decided before coming into force of the judgment in the case of Pranay Sethi. Stop. On this, Mr. R. Goswami submits that he may be allowed some time to produce an authority in this regard to press upon his point that the judgment of the Pranay Sethi is applicable even in those cases which were decided prior to coming into force of the said judgment, where appeal is pending in such cases. Stop. The prayer is allowed. Let this matter be listed again on next week. 14th May. 14th May. Let this matter be listed as a part-heard matter again on 14th of May. Is it okay?
Okay. Okay.
Item 11.
ये तो सेपरेट ऐसा फाइल बनाए रखे. Yes.
Totally. Well, is covered by the judgment of the honorable court.
Which judgment?
This is the-
That is submission.
Yes. Well, make your submissions. How it is covered.
My lord. This instant petition also, the trial court judgment, lordship, dated 16/12/2016. Passed by the
No,
learned
it was decided by a single.
single judge.
So is there any authority?
Lordship, as per sections 4, subsection 4, there must be authority, Lordship, by the chairman.
Yes.
And unless there is a order, Lordship, thus a member judicial cannot sitting singly and adjudicate the claim.
No, that you have to and that you have to show to this
Yes.
court that there was an authority.
Okay.
There cannot be any presumption that there must be an authority.
But Lordship,
If there is an authority, it has to be shown by the.
correct, Lordship. In that case, Lordship, a direction may be passed to the Railway Council, Lordship, to make an inquiry whether there is any.
You are not appearing for railways.
I'm for the respondent, Lordship. I'm for the private party.
Who is for the railways?
Railway.
Appeal.
Okay, there was. You are the appellant. No, in this case also there was no authority.
We cannot.
There was no authority. But the
We cannot-
railway is saying,
We cannot assume that.
no, whether, have you verified it?
Because single judge is only pass the order.
No, it appears that single judge passed the order, that is apparent. But the question is whether there was an authority or not. Authority,
No authority is given. There is no such
Mm.
kind of.
that may not be in the record of this case.
Yes.
That may be an administrative order, which may be there in the administrative files maintained by the Railways Claims Tribunal. So, but record is of the appeal. Record is of the claim case. Otherwise, many such cases are coming. You find out. Whether when the impugned judgment was passed,
Ask for what it, 16/12/2016.
whether on 16/12/2016 there was any authority, this can be easily found, ascertained from the Railway Claims Tribunal, from their official files. You find out. Heard Mr. D.K. Day, learned standing counsel, learned Railway Council appearing for the appellant. Also heard Miss M. Sharma appearing for the respondents. Learned counsel for the appellant submits that in the instant case, the impugned judgment has been passed by sole member of the Railway Claims Tribunal, namely member judicial. However, he submits that Section 4 within bracket 4 of the Railway Claims Tribunal Act 1987 no, Section 4 within bracket 2 of the Railway Claims Tribunal Act 1987 provides that a bench of the Railway Claims Tribunal shall consist of two members, namely a judicial member and another technical member. He submits that though Section 4 within bracket 4 of the said Act empowers the chairman or any other member authorized by the chairman in this behalf to function as a bench consisting of single member and exercise the jurisdiction, powers and authorities of Railway Claims Tribunal. However, in the instant case, it appears that no such authority under Section 4, Clause 4 of the said Act was given to the member judicial. Hence, he submits that this appeal may be remanded back to the Railway Claims Tribunal again to dispose of the case afresh by following the provisions of law. Stop. On this, a query was posed as to whether in the instant case any general order has been passed by the chairman Railway Claims Tribunal under Section 4 within bracket 4 of the Railway Claims Tribunal, empowering the member judicial to decide the claims cases sitting singly. He submits that no such, on this learned Railway Council submits that no such authorization is available in the records of records have been received. Records of this case. It appears that no records of the Mr. Counsel. Which records you have seen?
Yeah, I have asked for this RTC, RCT's record, this one.
The Railway Claims Tribunal's record is not before the court.
So that I have, that also I, because I am not appeared before that.
You have not gone through that. Then you are not in a position to say whether such authorization is there or not. That you.
That I have take the instruction.
Yes. What was the last name?
But what? Then just interfere, Lordship. Kindly, Lordship, there is a Supreme Court judgment which is also discussed in this judgment also. That is para 3, Supreme Court judgment. This is the judgment, and that is discussed in that instant judgment also, Lordship. It is specifically stated that the Constitution amended para 3, Lordship. There has to be a double bench, Lordship. Para 3
No, that nobody is disputing.
Yes.
That proposition of law, nobody is disputing.
Lordship.
That it has to be a bench consisting of 2 members. But there is an exception under clause 4, section 4, clause 4. We only are saying that you ascertain whether there was any such authorization on. So if we are certain that there is no such authorization, then this judgment will go.
That part I will see. But
Wow.
Supreme Court what says Supreme Court?
No, we are not.
Regarding this part, Supreme Court does not say anything. Supreme Court strictly stated that there has to be a two judicial member. There has to be two judicial.
No, but there is a. Whether Supreme Court has.
Because Lordship, this is an act of 1987.
In that regard, Lordship,
No, Supreme Court's judgment is not regarding administrative railway claims tribunal.
Lordship, I would like to peruse one judgment of this
Commonly stated.
in
No, this I have gone through, I have
Yes.
discussed it. Here, if there is an authorization under 4, even a single member can decide.
Lordship, I have furnished one judgment of the Honorable Gujarat High Court. Lordship, in para 6. Lordship,
Yes.
in last paragraph,
Yes.
from the aforesaid decision of the apex court, it is clear that since question of law and interpretation is involved, the single member of the tribunal cannot hear and decide the OA, and subsequently, since he was administrative member, he has no jurisdiction to decide the matter singly, as only judicial member in some of the cases can decide the matter singly. So here,
Here, it was judicial member.
yes.
So if 4 authorization is there, he can decide.
Here, this judgment pertains to Railway Claims Tribunal, Ahmedabad bench. So this matter pertains to railway matters, Lordship. And accordingly, Lordship, this order was challenged before the Supreme Court, and the Honorable Supreme Court upheld this order, Lordship. I have also furnished this.
But the statutory requirement of
Yes, Lordship. So unless
authorization is to be ascertained first.
yes,
What was the last line, Abhishek? Records. Stop. This court is of the view that if any general order of authorization is passed by the chairman, Railway Claims Tribunal, it may not be kept in the records of the instant case. However, same may be available. Same might be available in the official administrative files maintained by the Railway Claims Tribunal. Therefore, learned counsel for the appellant, within bracket learned Railway Counsel, is requested to take instruction from Railway Claims Tribunal as to whether any general authorization under section 4 within bracket 4 of the Railway Claims Tribunal Act 1987 was there when the impugned judgment was passed by the member judicial only sitting singly. Stop. If any such authorization was there, a copy thereof shall be furnished by the Learned Railway Council on the next date fixed. How much time will you require? Let this matter be listed again on 5th of June.
Lordship, in this case, at the time of when the stay was granted, we were directed to deposit the entire amount with interest. And on 27th of February 2026, the entire amount was allowed to be withdrawn by the claimants, Lordship. And the tribunal, while passing the judgment, gave us liberty to recover the amount from the owner because there was a violation of deal. There was a fake deal. As such as your lordship, at this stage, we may given the right to recover as per the Nanjappan law settled in the Nanjappan case.
The tribunal itself gave you that liberty.
Yes, your lordship, but now since the entire amount is withdrawn and the owner is not appearing, your lordship.
Still, that owner is not before us.
It's always a- but the wakalatnama is not.
Actually, tribunal order is their lordship, actually. Actually.
Now, when tribunal has allowed you,
Yes, recover the amount.
why you need that authorization again
Yes, lordship.
from this court?
This court is not required, lordship.
You have already been empowered to do that by the tribunal. What grievance is there against the tribunal's order?
Paragraph number 10 is very much clear, lordship.
Otherwise, you don't have any other case in this appeal. Then we are disposing of this appeal in light of your submission that you can recover the same. No. What is your submission? You are for
I am for the respondent number 124, lordship, claimant side, lordship.
what were the grounds which you took in the appeal?
From the life. So paying recovery.
But that you are not pressing.
The amount has already been withdrawn, your lordship, and the owner is not appearing before this court.
Actually, lordship, there is no ground of the appeal, lordship. Already the recovery order is there, lordship, and the one is member of the tribunal, lordship. So,
No, is it your submission that if you are allowed to recover the amount from the owner as was directed by the tribunal, you are not pressing for any other grounds in this appeal?
yes, lordship.
You are sure?
Yes, lordship, there is no any other ground in the member.
No, I am asking her.
We may be allowed to recover as per the settled law.
Heard Miss A. Biani, appearing on behalf of Mr. R.K. Batra, learned counsel for the appellant insurance company. This is item number.
12. D.K. Kolita for respondent number 1.
Also heard Mr. D.K. Kolita,
Respondent number 1 to 4, lordship.
appearing for respondent number 1 to 4. This appeal under section 173 of Motor Vehicles Act has, 1988, has been preferred by the appellant insurance company, namely New India Insurance New India Assurance Company Limited, impugning the judgment dated 13/12/2023, 2016, passed in MSC case number 1972/2013, whereby the appellant insurance company was directed to pay a compensation amount of rupees 6,55,800 along with an interest at the rate of 6% per annum to the claimants, and thereafter, where is the recovery part?
Loss,
No, in the award.
your loss, paragraph number 10, Lordship. Paragraph number 10 of the.
And thereafter,
right of judgment. Last part.
the insurance company, thereafter appellant was also given a liberty to recover the amount of compensation from the insured, that is, the owner of the offending vehicle, if it desires to do so. Learned counsel for the appellant submits that, in pursuant to the directions of the court, the appellant insurance company has deposited entire compensation amount which was awarded to the claimant respondents along with interest before the motor accident claims,
Registry of this court.
before the registry of this court, and same has also been withdrawn by the claimant. Learned counsel for the appellant further submits that under such circumstances, the appellant does not intend to pursue this appeal, provided it is given liberty to recover the amount of compensation paid by it from the respondent number 5, that is the owner of the offending vehicle. Stop. After considering the submissions made by learned counsel for the appellant, you are sure about your submissions? Learned counsel for the appellant, this appeal is closed with an observation that the appellant shall be at liberty to recover the amount of compensation paid by it to the respondents. Respondent claimant from the owner of the offending vehicle, namely the respondent number 5. With above observation, this appeal is hereby. No, last line क्या लिखा? Only last line. Comma, owner of the offending vehicle, comma, if it desires to do so. No, that is not it. If it decide to do so, as per the guidelines laid down by the apex court in this regard. With above observations, this appeal is hereby disposed of.
Item 30. Item number 13.
Yes, Mr. Goswami.
The bill was filed under section 163 of the parliament. This has now been amended as 164. What has happened in this case was it? The date of accident here in this case was 2014. And the date of judgment was 2015. A similar question also would come up here. Retrospective application, because after the judgment and during the pendency of the appeal, the act was amended by the notification on 22nd May 2018. Then
Act was amended in
22/5/2018.
yes.
This is the it's probably there already in the file. So this has been argued on several days.
Second schedule was
The earlier schedule also has been entirely replaced. Now there is one fixed amount of compensation rupees 5 lakhs per day.
but it will not have retrospective effect.
That is the issue.
That is by, we have Supreme Court has also held it.
Where is that judgment?
Calcutta High Court, this has been optioned by the Supreme Court, has been the case of India Insurance Company versus Formula 100. Both the Honorable High Court also has held it to be earlier. In case I was arguing against it, but still Lordship. Honorable High Court also held this in the of retrospective application. This is High Court. I'm giving that. This is the judgment of both the Supreme Court and the High Court I'm giving for.
Which judgment you are relying?
Same thing. That should have a one is that Vijay Mia of our High Court. I'm giving this Vijay Mia. The other is that Lordship.
Which para? Vijay Bhuya.
There are 27.
Please read.
There are 26 Lordship. question therefore needs to be considered are whether the amendments relates merely to procedural matters or whether the application of the amended second schedule in the pending proceeding to greatly affect vested rights of any of the party. The context in which the amendment took place is also a relevant factor, wherefrom inference can be drawn as to the applicability of the amended provision in the pending proceeding. The provision of paying attention compensation is under the Motor Vehicle Act itself is a social welfare legislation. And in order to take forward the social welfare object, the scheme of the section 163 was introduced for providing speedy relief to the victim of the vehicle accident on structure formula basis as per the second schedule. Therefore, the provision of the second schedule basically relates to a procedural matter, which provided the procedure as to how the compensation shall be calculated or paid in a claim under section 153A. And as such, apparently the second schedule merely relates to a procedure and not substantive law creating or extinguishing any right. Paragraph 27. From the object and reasons of the Motor Vehicle Amendment Act 1994 also, it is clear that the section 163 was introduced the Act by way of Social Security Scheme in order to grant immediate relief to a section of the society whose annual income is not more than 40,000 on a basis of the structured program. Since the provision of section 163 of the Act was introduced as a social security scheme, is only a scheme to give relief to the victim of vehicle accident belonging to certain class, and the second schedule is only a procedural tool to determine compensation in a claim under section 163A. Amendment of such procedural provision can by no means, no stretch of imagination, be held to affect any vested right. The context as indicated in the notification amending the second schedule as well as the judicial pronouncement in which the amendment has been made also give indication wherefrom it can be inferred that the amended provision of the second schedule shall be applicable in a pending proceeding. Thus, keeping in view the basic object of introducing section 1 and also amendment of the second schedule, which merely relates to procedural matter and the social welfare object of the legislation, as well as the context in which the amendment occurred, this court is of the considered opinion that the amended second schedule has to be taken into account in the pending proceeding under section 163A for deciding the quantum of compensation.
Next para.
Next para, there is no gainsaying that the appeal is a continuation of the proceeding, and as such, the amended second schedule has to be taken into account in the present appeal in deciding the claim under section 163 of the Motor Vehicle. This more or less is probably in line with that Urmila Haldar's case decided by the Calcutta High Court. That has been again, Lordship, supported by the Supreme Court that it's a correct view. Urmila Haldar.
Read Supreme Court.
Supreme Court, that small decision, Lordship.
Yes.
Got the decision, Lordship.
Yes.
Urmila Haldar. Thus, we may come to para 9, para 10.
Of apex courts.
Apex.
Yes.
The order of the High Court is well discussed, and we agree with the view taken. We may, however, add that a beneficial legislation would necessarily entail the benefit be passed on to the claimant in the absence of any specific part of the same. In the present case, the liability of the apparent insurance company has not been interfered with. Only the computational mode and the modality have been clarified, which rightly has been noticed by the High Court, and accordingly, the claim has been enhanced to ₹5 lakhs. 50% shall be paid. This is there. It has then we have to refer to the Calcutta High Court, what has been supported by the appellate by the Calcutta High Court is in para 14.
Para 14.
What is the issues, Lordship, that is different at the final year comes under 103. May I complete this final, little bit too long, para 118. It's a convention of the discussion in the previous paragraph.
Yes.
Therefore, the conclusion seems to be inescapable that while deciding pending claim applications, appeals post May 2018, the new schedule ought to be applied by the tribunal. This court for determining compensation payable to the legal heirs of an accident victim or to the victim himself, regardless of the new schedule is beneficial to them or not. Regardless of which way it goes, either in his favor or against him. So this is this view, Lordship, that this is applicable retrospectively, has been upheld by Supreme Court in
No, it is not retrospective application. It is application to pending proceedings. And court has held that the appeal is a continuation of the proceeding. Therefore, even if the original case was decided before amendment, the amendment would be applicable to the case at appellate stage. Yes, Mr. Kalita.
If I may,
Yes.
although it seems to be a big lots of difference, our award lots of may come to the award. I don't think we are in a very big amount. That award. The award itself is the amount that has been awarded under that particular head is not big. It almost comes to the same amount as 5 lakhs. 5,76,000 is the basic award.
Now, what was the awarded amount?
Page 16 of the memo of appeal and page 9 of the judgment.
10,66,000.
10,66,000 is the final award. But Lordship, I am coming to the head wise, Lordship. It has some relation to my submission.
Yes.
It was loss of dependency is 5 lakhs. 5,76,000. Then Lordship, there's another point why I'm saying this. I think we need to focus on this particular. I'm not directly opposing the same, but I just would like the Honorable Court to also see. The earlier Lordship, unamended act, the second schedule, there's no provision for some things that isn't given in this. That the judgment was rendered in the context of the unamended.
The conventional heads.
Conventional head, there's almost nothing. 2,500, 5,000, that is, those were the only 2 heads, and for medical expenses, it was 50. So these are also the grounds of appeal that I have taken. As it is now that 5 lakhs is minimum, 5 lakhs and 5,76,000, even my learned friend really would have no objection. 5 lakhs, if they on principle we agree that it is retrospectively applicable, it will be reduced by only 76. But other heads, Lordship, also need to be. I leave it to Lordship because there is no clarity whether these are payable or not. I'll go by this Honorable Court's statement. Decision in this.
No, what is your submission?
My submission, Lordship.
Under 163A, these conventional heads compensation ought not to have been paid.
Yes, sir. This ought not to be, if it would not have been amended earlier, subsequently. I would have said that these are outside the purview of section 153A. That was my submission at that point of time.
After amendment, can it be paid?
Yes, sir. So after amendment, can it be paid? That I am leaving to the, because I could not find any supporting judgment any particular view expressed by any court, whether it is payable. So Lordship, but in any case, Lordship, even if it is paid, whether it's within the year, current present limitations, present
By
Lordship.
Pranay Sethi's judgment.
Even if it is payable,
Because what I believe, Lordship, that 5 lakhs cannot be interfered with. That has to be paid as basic compensation. Whether these additional heads, if these are payable, this has to be paid in addition to 5 lakhs. And if these are, whether these are payable or to what extent payable, that has to be decided. Like Lordship, funeral expenses, 20,000 hardly makes it as 15,000. This pain and suffering column would not be there, it's a death case. Pain and suffering would be, cannot be a head when it's a death case. Loss of consortium, Lordship. For the wife, it should be 40,000 again.
Okay.
For the 2 children, Lordship. If it is, I'll just, in the earlier case, I did not introduce that as a judgment. But yes, Supreme Court, in a recent judgment, Lordship, discussing in Nanuram and Pronacity, did not give this other way to the children or the judgment I have it. Yeah, just. So even if it is given, Lordship, it should be not 1 lakh but 80. I'll produce the judgment. Okay, Sriram Generations Company versus B.S. Rawat. The loss of love and affection, again, that once this 40,000 is given, that 25,000, column number 6, that is also not paid. It's very clear. After loss of consortium is given, the pain and love and affection cannot be again given.
Yes.
Towards medical expenses of disease, I don't know, I think I cannot make a submission this is payable. But earlier it was restricted to pay. It's a deviation from the earlier.
No, when the case is under 163A. When the case is under 163A, computation has to be according to second schedule.
And it's not there in the new provision also.
Okay. Yes, Mr. Kalita. Anything else, Mr. Goswami?
This is my not much, very limited submission.
Mr.
Yes.
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 The first issue that my learned friend has raised regarding the prospectivity and retrospectivity. Definitely, Lordship is well aware, it will be prospective. No retrospective effect can be given the act where there is no specific word mentioned in the said act. Has there been any specific word that this or notification that this notification will apply prospectively? Then the question of prospectivity will retrospective.
No, what is your reply to his submission that in view of the judgment delivered in Urmila Haldar,
Urmila Haldar judgment, Lordship? Yes, I am coming paragraph 10 again.
10 of the?
That's Urmila Haldar Supreme Court judgment.
Yes.
Lordship, in this case, Lordship, initially only 2 lakhs was paid to the claimant. Now, subsequently, Lordship, the new amendment came into force. So, the court only emphasized on the issue that since it is a beneficial legislation and question of High Court has already given as far a new provision of law, though we are not going to interfere with this case. Let's see the paragraph number 10. Yes, I'm reading, Lordship, 3 lines.
Yes.
The order of the High Court is well discussed and we agree with the view taken. We may, however, add that a beneficial legislation would necessarily entail the benefit to be passed to the claimant in absence of any specific part to the same. So here in this case also, Lordship, the Honorable High Court of Calcutta has given retrospective effect only on the ground that since it was a beneficial legislation and claimant, if we apply the new law, then claimant will get little bit more benefit amount than it was passed by the tribunal. Accordingly, High Court has considered that view. Nowhere it is stated that it will give retrospective effect. So you will see the language. Since it's a beneficial legislation,
So on that count only, the High Court High Court has granted the new provision of law and Supreme Court upheld the order of the High Court. High Court has nowhere stated that it will give retrospective effect. First thing. Second question that my learned friend has said regarding the substantive law and procedural law. So 163 is not a procedural law. It is a substantive law as held by the Honorable Apex Court. Substantive law and logic is well aware what is procedural law, what is substantive law. Substantive law is a law. If the law deviates, then someone will suffer. Substantial law creates some burden or obligation or right of a person. So it is also well settled by the Supreme Court that 163 is a substantive law, not a procedural law. Thus, I am giving lordship judgment of this Honorable Supreme Court in the case of Lordship Shakti Tubas reported in 2009. Which I am giving judgment. Lordship, this judgment regarding only prospectivity and retrospectivity. Just I'm reading the new judgment of 2025.
Yes, in Shakti Tubes,
Lordship.
what you want
Yes,
to show?
this judgment, oh yes. Para 24, Lordship. Para 24 and 25. Regarding prospective effect and retrospective effect. Thus I'm reading paragraph 24. Mary Lordship.
Para?
24.
No, what you want to show? What is your?
Regarding prospective effect and retrospective. First judgment.
No, it is not his submission that
Yes.
it is given retrospective.
Yes.
His submission is that any amendment is applicable to pending cases.
Yes.
And since appeal is pending,
No. That High Court, Kolkata High Court judgment never says that so, Lordship. And also notification never says so, Lordship. Notification is quite silent, Lordship. No whisper regarding the prospective effect. It will only say that it will come into effect on the date of publication.
no, this court,
Yes.
in the case of Vijaya Bhuya,
I am also relying this on a court of this judgment of this honorable court also. It was decided in 30 of March 2022.
what is your submission regarding Vijaya Bhuya? You have
But that is why I am relaying this judgment also. There are 12 of this judgment. This has also given retrospective effect also. Vijay has given prospective, it is given retrospective. Same order of same honorable court also. Para 12, which regards the compensation amount of rupees.
just a minute. Yes.
Para 12 also. Which regards to the compensation amount of rupees 6,83,600, which 7% interest from the date of filing, that is so and so, awarded by this learned trial court, calculated as per schedule of the Act. And the decision of the Apex Court, it is seen that the claimant had made the claim under Section 163A of the Motor Vehicle Act. The notification of Ministry of Road Transport and Highway bearing number so and so, compensation claim under Section 163 of the MB Act, wherein the amount has been laid down for awarding compensation under Section 163 of the Act of the Motor Vehicle Act 88 was notified on 22/5/18, while the date of accident was on 31/11/16, and nothing about retrospective effect is mentioned in the notification. Therefore, it can be logically inferred that the notification dated so and so is not applicable in this case. So, Lordship, same judgment of this honorable court stated that since notification is silent regarding the effect only from the date of its notification is published. So question of Lordship, retrospective effect will not come. So accordingly, Lordship, this honorable court held that the awarded amount by the learned tribunal was rightly held.
So which one to follow?
The lawsuit will go by the apex court judgment regarding the prospective effect and retrospective effect. What the judgment has deal with the effect. So definitely lawsuit will accept the honorable apex court order.
Which one?
The 2009 order lawsuit. Para 24 and 25. Two 2009 Supreme SC 1194.
No, please read 24.
Logic 24. Generally, an act always be regarded as prospective in nature unless the legislature has clearly intended the provision of the said act to be made applicable with retrospective effect. It is the cardinal principle of construction that every statute is prima facie prospective unless it is expressly or by necessary implications made to have a retrospective operation. The aforesaid rule in general is applicable where the object of the statute is to effect vested right or to impose new burden or to impair existing obligation, unless there was in the statute sufficient to show the intention of the legislature to effect existing rights. It is deemed to be prospective only. Nova constitut fusarius formen imponere debate non pretenditis. A new law ought to be regulate what is to follow, not the first. So here is my vested right is involved lawsuit. That is why the equal lawsuit retrospective cannot be given. Next lawsuit, para 25 also may see lawsuit. Para 25. There is no dispute.
Yes.
There is no dispute with regards to the facts that the act in question is a welfare legislation which was enacted to protect the interests of the suppliers, specifically supplier of the nature of a small scale industry. But at the same time, the intention and the purpose of the act cannot be lost sight of. The act in question cannot be given retrospective effect so long as such as an intention is not clearly made out and derived from the act itself. So if the act lawsuit is silent regarding the effect of prospective or retrospective lawsuit, then the only lawsuit it will be of prospective effect. Let me complete. No, one. Then lawsuit one judgment. I have only the one copy lawsuit. Just I will read the relevant paragraph. I will give a extra copy lawsuit later on. 2011 8 Supreme 301.
Yes.
Logic. In this judgment logic, in para 15 and 16, a long paragraph logic, I have to give a copy of this. It is stated as special provision override the other provision of law. So logic 163 is a special provision. Thus I am giving you a copy of this extra copy. In para 15 and 16, note down. Para 15 and 16 says special provision override the other provision of law. So 163 definitely is a special provision lawsuit. Definitely it will override the other provision. And giving extra copy lawsuit, only one copy. And also 2025 Supreme 113, it says so 163 is a special provision. Yes. I'm just reading lots of more paragraph. 2025 Supreme SC 1139. Wakia Afrin versus National Insurance Company Limited. What I'm reading. We cannot but notice that section 163 is a special provision brought in which is a non-obstantive clause which overrides not only the entire provision of the Motor Vehicle Act 1988, but also any other law for the time being in force and any instrument having in force of law. We cannot but understand the non-obstantive clause having a superseding effect over a law of insurance or even in terms of the policy, which definitely is an instrument having in force of law. It is also to be noticed that Section 163 makes liable to the owner of the vehicle or the authorized insurer to pay in accordance with the schedule in the case death or permanent disablement due to the accident arising out of use of the motor vehicle. Right is that the principle that is liability with respect to an accident is on the tortfeasors, and the case of a motor vehicle accident, if the tortfeasor is a driver, the owner has the vicarious liability, which liability is determined by the insurer when there is a valid policy. The liability is essentially of the owner, but the provision in addition to the insured owner makes liable the authorized insurance company too. Hence, when there is a valid policy issued in the name of the vehicle involved in the accident, a claim under Section 163 as per the words employed in the provision according to us covers every claim and is not restricted to third-party claim without any requirement of establishing the negligence. So 163 lawsuit is a special provision. It's over all provision of law. If there is a valid policy, not only the third party, other claim also can be made under Section 163. It says. So from all this judgment lawsuit, it is very much established that the new notification of Motor Vehicle Act is lawsuit of prospective nature. It cannot give any retrospective effect. And even what my learned friend has stated, he is not objecting the other part, only the future prospect. Here also, if you consider future prospect, there are three claimants. In three claimants, three future consortium will come. He is objecting on the consortium part. Three consortium lawsuit, the filial, parental, and
No, his objection is also with regard to the compensation awarded under conventional heads.
conventional heads
Like-
loss. Yes, that is what I'm saying. If we go by the lawsuit second schedule, then lawsuit this amount also come. Only 3,000-4,000 difference will come. That is why we did not prefer an appeal, because if you go by the second schedule lawsuit, applying the multiplier and this multiplication lawsuit, then this amount also 10 lakh something is come. So that is why we did not prefer an appeal. His income was lordship mentioned in the claim petition as 12,000 lordship per month and 120 rupees per day allowance. So since lordship it is a claim of 163, our expectation only to lordship regarding that as per second schedule lordship. So as per second schedule lordship, if you go by the second schedule, his age was 36 lordship.
Yes.
36, if it is his age is 36 and multiplier will come 16, and there is also a sort of multiplication considering the income per month. And if you consider his income per month 3,006, 3,000 per month. 3,000 per month, you will see the second schedule. Plus you got second schedule also. Into 12 into 540.
Second schedule has been deleted in the পুতুল পুরনো এমবি একটা আছে নাকি এমবি অ্যাক্ট Yes. Second schedule before amendment.
Before amendment laws. So before amendment lordship, as shown the schedule lordship, only up to 40,000 annual income is there. So our income was lordship 12,000 per month. It will around lordship 1 lakh, 1,44,000 probably. Lordship. So this schedule will not cover our lordship. Not that. 40,000. 1,44,000 our annual income was there. 12 lakh one, where lordship was just not adding 120 rupees that was given as
Then 163A is not applicable to your case.
So lordship,
But you filed case under 163A.
there is no bylaws. In one judgment that I'm referring, in this court also lordship court has given 12 lakh something. That's I'm referring judgment. And no deduction was also get. Deduction, that 50% deduction was also not made lordship. It was 2010 Supreme 804 Lila Gupta case.
No, when the second schedule under section 163A is applicable only to cases where the claimant or the deceased is having income up to 40,000 only.
Lordship.
It is not required to prove lesson. The main,
Yes.
he has to prove
There.
lesson. That is the main credit.
Yes.
Lordship. In this case, lordship,
Here, he has got the benefit of
Yeah.
not requiring to prove the lesson. You
And,
cannot raise it now after so many years.
had it been the defense of the learned insurance company also?
It's not
Yeah,
been
that was the
objection on this point. There's never.
Lordship, even if
Today I'm taken by surprise at this point. as well.
that is different issue. Even if lordship, I have not filed any cross examination, I have the absolute right to defend my award. That cannot be lordship object my anything. I have my right to defend my award. I may not file any cross objection, cross appeal. In this case, lordship, Supreme Court in the case of lordship, Leela Gupta versus State of Uttar Pradesh, that's also 163 case lordship, awarded 6,04,800 and no deduction was given lordship. High Court has deducted lordship 50%. It was lordship Supreme Court has held. It was High Court has erred in deducting 1/3 of the compensation assessed after ascertainment of multiplication.
The cases which you are relying,
Yes.
should you give a copy to, and on what point you are relying that case?
163A case lordship.
Why you are relying this?
To show lordship that even in 163, this the same procedure that the tribunal has granted lordship that can be followed and no deduction lordship.
Then what is the necessity of having a structured formula?
Lordship, even it is structural formula, it was made in 1988. Lordship is well aware. Although there is no question, future prospect is lordship is a new aspect. It was not even the new act or old act. It was given lordship after probably it was 2010 or 11. The judgment lordship the tribunal has referred. So question of future prospect was not there. Now question of prospect, even though it is not in the new act, now all this court lordship granting future prospect, considering the lordship this judgment of the apex court. So though lordship the schedule of MSCT Act is not specified regarding the future prospect and 163 applicability.
No, you want also compensation against the head future prospect.
Lordship future already given lordship that can lordship my humble submission in that should not be interfered lordship because the honorable apex court in this court has availed in Leela Gupta case. All this lordship law, although it was made in 1988, lordship subsequent to that several judgment has been passed. Other some in some cases like this case, my learned student is relying Kolkata High Court judgment, he is giving retrospective, other all judgment giving prospective effect. So there might be some lawsuit exception, that exception should be lawsuit should not consider in my case also, because it's a welfare legislation, and now this family, we have to look into the family condition also after demises of their bread earners.
Now, in your case,
Yes.
while computing loss of dependency, whether loss of
Lordship may consider loss of dependency, and Lordship may also consider this judgment of this Lila Gupta, where Lordship no deduction was given. Then Lordship amount will be almost remain same.
okay.
So only on the basis of that only issue is that Lordship, there only submission is that it was 163, so it will go on structured formula basis. That is the only Lordship grounds of appeal.
Yes.
Now, after 2 years, new law again, another new law will come. So that law, if Lordship apply that law in my case also, and if subsequent to now, just I'm giving an example Lordship. Earlier it was that Lordship compensation appointment was there. If a government employee dies, their family member can apply or get that service or job. Now that has been stuck down. Now the government is saying that now we are not giving accommodating any employment. We are just giving the full salary up to the date of disease superannuation. So in motor vehicle act also losses of new act may come after 2 years, 3 years. If that new act lordship curtail my right, whether it will not be prejudiced to my client lordship. A case of 2014, and new act has come in 2017, and this is not fault of the lordship, this claimant.
Yes, Gosu.
Lordship, I have some subtle that.
We will continue at 2.
But it will have it well. Item number 27. So I have taken the consideration. And we taken up one. Then another big item immediately after this.
Item number 27.
27. Take it.
Mr. R. Goswami, learned counsel for the appellant, prays for an adjournment on the ground of personal difficulty. Mr. S. I. Akan, learned counsel for the respondent, does not oppose the prayer. Hence, the prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry.
Date.
28th July.
So.
We'll continue.
Lordship.
My lord, I'm praying for some communication with respect to item number 28 of the daily list, my lord. My lord, conducting counsel, Mr. Pilkey Toto is indisposed as on today, man. The matter will be passed over for the day, my lord.
You have informed the other side.
The appeal, my lord.
You have informed the respondent side.
My senior. From my instrument.
Heard Mr. What is your name? R. Barua. H. Barua. Learned counsel for the learned counsel appearing for Mr. K. K. Datta. Learned counsel for the appellant, who submits that since the conducting counsel for the appellant is indisposed, the matter may be passed over for the day. He has submitted that he has informed learned counsel for the respondents regarding his prayer. The prayer is allowed. Yes.
So yes, I will conclude my submission. So only on the one judgment that I am relying. Here, Lordship, this Honorable Apex Court has passed a very reasoned order regarding conventional hearing, Lordship. Lordship, kindly have paragraph 11. This is a case, Lordship, arising out of petition under section 163A. wherein lordship a minor died in the accident and a claim petition under section 163 was filed. The Honorable High Court lordship has relied upon the schedules 2 and accordingly awarded 2,50,000. The appeal was preferred lordship findings of apex court lordship at page 11. Paragraph 11. The same reading. As the claim was made under section 163A of the Motor Vehicle Act, since the deceased child was not an earning member, the tribunal has considered notional income as per Schedule 2 for the purpose of fixing compensation. The tribunal has awarded compensation by notional income of the deceased at rupees 15,000 per annum by applying multiplier 15. Awarded compensation rupees 2,25,000 towards loss of dependency with interest 6% from the date of judgment. When the appeal was preferred by the insurance company as well as the appellant hearing, the impugned common judgment, the High Court has dismissed the appeal preferred by the insurance company and appeal preferred by the claimant while confirming the compensation awarded for loss of dependency rupees 2,25,000, has awarded a further sum of rupees 15,000 for funeral expenses and accordingly granted a total compensation of rupees 2,40,000 with interest 6% per annum payable by the respondent to insurance company and by permitting to it recover the same from the respondent number 1 owner of the vehicle. Number 12. In a judgment in Uttamma, this court has observed that the central government was bestowed with the duties to amend Schedule 2 in view of Section 163A3 of the Motor Vehicle Act 1988, but it failed to do so. In view of the same, specific direction were issued to the central government to make appropriate amendment of Schedule 2, keeping in mind the present cost of living. In the said judgment, till such amendments are made, direction were issued for award of compensation by fixing a sum of rupees 1 lakh towards compensation for non-earning children up to the age of 5 years old and a sum of rupees 1,50,000 for more than 5 years old. In R.K. Malik, also this court has observed that the national income fixed under section 163 of the Motor Vehicle Act 88 as rupees 15 per thousand per annum should be enhanced and increased as the same continued to exist without any amendment since 14/11/1994. In Kishan Gopal, where the disease was a 10 years old child, this court has fixed the national income of rupees 30,000 per annum. In this case, it is to be noted that the accident was on 6/9/24. In spite of repeated direction, Schedule 2 is not yet amended. Therefore, fixing national income of rupees 15,000 per annum for increasing for non-earning member is not just and reasonable. In view of the judgment in Uttamma, R.K. Malik and Kishan Gopal, we are of the view that it is a fit case to increase the national income by taking into account the inflation, the devaluation and of the rupee and cost of living. In view of the same, the judgment of Rajendra Singh relied on by the learned counsel for the respondent number to insurance company would not render any assistance in the case of insurance company. In view of the above, we deem it appropriate to make the national income of the disease to be 25,000 per annum. Accordingly, when national income is multiplied with the applicable multiplier of 15, the prescribed in Schedule 2 for the claims under section 163 of the Motor Vehicle Act 1988, it comes to rupees 3,75,000. The appellant is also entitled to a sum of rupees 40,000 each towards filial consortium and rupees 15,000 towards funeral expenses. Thus, the appellant are entitled to the following amounts towards compensation. So, Lordship, in this case, court has rightly held that since this is a case of this act was passed in 1988, the compensation was Lordship considered at the time of Lordship 1988. Now it has Lordship passed more than almost Lordship 37 years. So Lordship definitely situation has changed. The cost of living Lordship has to consider. So on the basis of my submission, that is Lordship, I am submitting the compensation awarded by the Ranit Tribunal, considering Lordship rupees 3,000. It was, we did not prefer any appeal as my Ranit friend is objecting. I do not have prefer any objection, but we have Lordship insisted on the amount of compensation awarded by the tribunal. Rupees 5,76,000 was added towards dependency. If you go by the schedule Lordship, it will come 5,40,000. Second schedule. So only 30,000 difference is there. Others Lordship funeral expenses 20,000. It was 15,000 is fixed. Now after Lordship 20 years, 5,000 has been enhanced. And nothing to say, I think nothing to Lordship stands here. pain and suffering 25,000, loss of consortium, it should be lordship more than 1,40,000, but only awarded 1 lakh. Since three claimants are there, spousal, filial, lordship, and this parental,
Parent.
three will come. Others, lordship, others as medical expenses is there. Medical expenses has been lordship given as per also medical prescription. So only issue is lordship regarding love and affection of the claimant number 1 due to death of the claimant 25,000 is that. That is extra lordship. So lordship, I think last 10 years they have been suffering. In 25,000 lordship, it cannot lordship fulfill their loss they have suffered since the death of their father and husband lordship. So my humble submission lordship, no interference is necessary in the order passed by the learned lordship tribunal. That may be appeal lodged and appeal may be dismissed lodged.
Have you received any sum? 50% or?
Or perhaps lordship 50% was perhaps, so I'm not sure. Probably it was received for 50%.
Yes.
Just coming to the immediate point, as husband, he has relied upon the Supreme Court, even after so many years, has taken the notional income as 25,000 per year. But here in this case, only 36,000 has been taken. I have not of it. In the instant case, it is taken at 36,000 per year. That is not my issue. All I am trying to show is that judgment he has relied upon, that has even after so much of year, it has been increased to 25,000 because of the limitation of a statutory provision. Plus, if I'll come to a few aspects, because also here the amount is not so much an issue as the principles involved. Amount is like, let's say, 5 lakhs and 5 lakhs 76, as I have already said. The tribunal has awarded for loss of dependent 5 lakhs 76, I'm saying it should be fine. And also more on the principle that what should be applied, the law which is required to be applied correct. Plus, the first thing, I'll go by one. First thing, the judgment, when I rely on the judgment, I read the whole facts and the entire judgment, not one para or one. The judgment of the Supreme Court, I'll come from there and go down to Calcutta High Court and got it. Lordship, this small 2-line para, Lordship, given the judgment Supreme Court. Para number 8, 9, 10. Lordship will see what the Supreme Court has appreciated about Calcutta High Court. You may see it, para number 8, 9, 10. Para number 8, 9, 10. Para number 8, this is what was canvassed by the appellant, New India Insurance Company, and what was Lordship argued by the respondent. Para number 8, Lordship, of that, Madam Urmila Haldan.
Yes.
So most of the doubts should be cleared from this. Learned counsel for the respondent, that is Urmila Haldan. Respondent submitted that the High Court has rightly taken a view that it is merely a procedural amendment which has to be given retrospective effect, and it is nothing substantive so as to affect the merits of the issue. That was the major objection of the Supreme Court submission. The next para is, having considered the matter, we do not find any reason to interfere with the judgment. That is what High Court has held. High Court has a procedural amendment, and therefore it has to be given at that. The Supreme Court, para 9 is very clear. Having considered the matter, we do not find any reason to interfere with the judgment impugned. With regard to the judgments of this court relied upon by the learned counsel for the insurance company, having gone through the same, we find that they are distinguishable from the facts of the present case, and the ratio of these cases would not apply to the present case. That means in this case, Supreme Court has upheld the submission made by the respondent, Urmila Haldan, which said that it's a procedural amendment and it should be retrospective in nature. Para number 10, it says the order of the High Court is well discussed. We agree with the view taken. Lordship, how can it be on one point? Supreme Court has gone through the entire year. I'll have to read more parts of the High Court judgment law. Only after it has agreed. It has not made any exception which part they did not agree. Or which part they have. They said, order of the High Court is well discussed and we agree with the view taken. We may, however, add that a beneficial decision would necessarily entail the benefits to be passed on to a claimant in the absence of any specific partnership. In the present case, the liability of the insurance company has not been interfered with. Only a computational mode and modality. This is the procedural part which has rightly been noted by the High Court, and accordingly, The claim has been enhanced to rupees 5,000. Plus, if section 153 is held to be by itself a court, it's substantive as well as procedural in nature. What is substantive about 163A? It's a right to get compensation, regardless of rash and negligence. That's the fundamental difference between 163A and 163 is not in the income. That part can be always modified by the assembly of the state. Is that in under 163A, a person is not required to prove rash and negligence. Basically, people of the weaker section of the society, they have find it difficult to prove rash and negligence. This special dispensation was created only for this. Okay, just indicate what your finger this vehicle is. If the involvement of vehicle is proof that this is the vehicle, then race is not material, he gets a compensation. But 166, therefore, not since so much of benefit has been given, it was boundary, a boundary was drawn. How much can within what the
And the schedule showing the how to compute the compensation. That is procedural.
the right to get compensation is substantive. It's both. I'll discuss Calcutta High Court and Guwahati High Court. It has dwelt on this particular point that this is both procedural as substantive in nature. It cannot be said that this is substantive. The right to get compensation has not been interfered with by anyone. And the act, amendment of the act, nor by the courts, nor by. That's procedural part. Is there a computational mode? How much is to be paid? How it is to be calculated? These are computational mode, and therefore it's called procedure. This part of the act is procedure. Calcutta High Court has very clearly dealt with. It has come earlier. Our High Court decision was a few months later, and has followed the same logic the earlier court. So now I'll come to this Calcutta High Court's particular logic. But what para number 103. Prior to that lordship, it must be said what was the issue before the Calcutta High Court? Para number 10. 14. Para number 14 may come. What is the issue before the Calcutta High Court? And why? What is their finding on that particular issue?
Yes.
It says, para number 14, with that in view, we invited such learned advocates to address us on the following. That's a large number of advocates had addressed the Calcutta High Court on this point. And number of advocates were invited to the court. Whether after amendment brought about by the said notification, this 22nd May 2018, the new schedule would be applicable to pending claim applications under section 163A before the motor accident claim tribunal, as well as the appeals arising out of awards delivered thereunder prior to 22nd May 2018. The response was all the advocates responded, and also I will come to it in para number 103. What was the outcome of this discussion? Also, I will come to para number 90. There's something I missed. It defines what is procedural or what is substantive.
Yes.
Para number 90 plus in NC Budras, the constitutional bench by a majority of 3-2 answered their reference by holding that the arbitrator appointed by the number 23. Substantive law is that part of law which creates, defines, and regulates rights, in contrast to what is called adjective or remedial law, which provides a method of enforcing rights. Our understanding of what is substantive and what is procedural is not inconsistent with the view law laid down in NC Budras by the Supreme Court. Para number 93. Guided by the settled principle of law, we have noticed in the preceding paragraph, we hold that section 163A of the Act has both substantive as well as procedural aspects. That part of subsection 1 of 163A, which confers the right on the legal heirs to bring an action against the owner of the offending motor vehicle or authorized insurer thereof for compensation, is substantive law. Why? The means by which enforcement of the right to receive compensation can be attained, that is determination of compensation by the tribunal as indicated in the second schedule, is procedural law and is very clearly laid down. It is also relied on the procedure. This part of the EA is, we are talking about second schedule, this part is procedural, and this is the part that has been amended. Lordship, now I'll come to that notification itself. Lordship may come to notification. How this amendment has been brought about, that is also what kind of words have been used to bring in this amendment. The character of the EA would be determined by the words used, Lordship. That notification.
Yes.
In the Motor Vehicles Act 1988 for the second schedule, the following schedule shall be substituted. The second schedule, see section 1 schedule here, the schedule for company, this should be substituted. This is that has been substituted. It has been brought in by way of substitution. And Lordship, as regard the impact of substitution, Lordship, I'd like to all the what is the effect of substitution? Lordship? I have made a small synopsis of it. I refer to some judgments which has interpreted the word not substitution in amendments while bringing about amendments. And also, probably also the judgment.
So after the amendment, in a fatal accident where death has resulted, he will get lesser. He will get lesser than a person suffering permanent disability.
In the Umila Halder's case, he has got, it was 1,13,000, it has been increased to 5 lakhs. In our case, it has been brought down from some around 16 lakh to 5 lakh. It's regardless of the amount. What will apply is the principle. When the earlier substitution notice has been explained, it is Jilay
Now, why you are relying Jilay Singh?
So that's what the impact of the word substitution. Whether we can still go back to it. But substitution means the earlier provision ceases to exist. It's not there. It was there. It was never there. It was replaced by the anterior. Also may come to this. There are 24, 25. I've also relied on under judgment. Just to bring in whether it's retrospective or prospective. It's in my other submission, the Calcutta High Court, the Supreme Court has it is in consistence with it, some judgments of the Supreme Court. What is substituted? What does substitution mean? Lordship, para 25 of Jilay Singh, Lordship may come to para 25. Please.
Yes.
The last line, Lordship. In Koteshwar case, a 3-judge bench of this court emphasized the distinction between supersession of a rule and substitution of a rule, and held that the process of substitution consists of 2 steps. First, the old rule is made to cease to exist, and next, the new rule is brought into existence in its place. That ceases to exist. All that we have in hand is the new rule. And the new rule also, as I said, doesn't provide for number of things. Any of that. It says state 5 lakhs. That's why I will limit the discussion around total. How much of medical expenditure is payable? How much of I'm not saying that they are not entitled to it, but I'm just trying to draw the distinction. Even the other judgment, Karnataka High Court also has beautifully explained what is the right and some justice.
Okay.
That's it, the same giving one submission regarding his Urmila Halder case.
Lordship, once I can go back to Urmila Halder, Lordship. I have not finished that. There has gone. Then there is under that part I had read only so that what is substantive and what is procedural in this case. Then I'll come to para number 103 also. Para number 103.
Yes.
An interesting feature is discernible in the new schedule, which is quite dissimilar to the old schedule. The age of the victim of an accident caused by the use of a motor vehicle and his earnings on the date of the accident were very important for determining compensation payable by the tortfeasor on the basis of the structured formula. That is in the earlier schedule. An appropriate multiplier had to be selected considering the victim's age. The new schedule makes no provision for determination of compensation based on the age of the victim. A young child and a aged person would get the same compensation, regardless of who the accident victim is, an adult or minor, and and whether the victim was an earning member or not. If the accident causes death, the compensation will be a fixed amount of 5 lakhs. Therefore, the victim's age and earning are no longer relevant. A fortiori, the date of the accident too may not be of much relevance, having regard to the plain language of the section, which does not give any additional importance to the aspect of the date of accident, except that the accident causing either death or physical disability must have involved the use of the motor vehicle, which have to be proved. The only thing to prove is this motor vehicle was involved.
Okay.
These are the only proof required for a claimant to succeed in a application under section 153K. So this assumes a great secret. It cannot be lots of overlapped. 163 one doesn't have to prove resident negligence, 161 has to prove and take sky's the limit, any amount of money. But 163 has availed of the benefit of that particular option. That other side did not ask him for proof of resident. He was spared that first. Because it's settled law. No question should be asked on grass and negligence. So how can he suddenly now claim for a benefit under 166? In our view, in view of our finding that second schedule is not part of substantive law, but is procedural law, there is no difficulty in holding the new schedule to be applicable for a claim which are alive, claim cases which are alive, either before the tribunal or are pending adjudication before the high courts in appeal. But with the caveat that it will not apply to claim cases which stand closed by result of attainment of finality, the awards upon acceptance of by the parties of which are closed that cannot be revoked. No appeal was filed, he has accepted, he cannot. It's only when appeal has been filed that will be a continuation. That's the next para is leaving aside the legalistic discourse as to whether section 168 is substantive law or partly substantive, partly procedural, and also as to whether new schedule will apply religion. We will proceed to consider and answer the issue on the basis of a reading of the plain and simple language, subsection 1 of section 163A. Even if the new schedule were considered to have prospective application only, there are good and sufficient reasons to hold that it will apply to pending claim applications. We may now elaborate why we are inclined to do so.
Okay, Mr. Lee.
It's a long list, I'll not go further.
No.
No, just that.
Finally, lots of whether
You have made out your point.
that's it, I'll come to another point. About that conventional heads. Conventional heads recently in 2025. Honorable bench of the Supreme Court also. It has discussed Magma versus Nanuram, it has discussed Pranay Shetty vote. And in spite of that, limited the hit only free as by Pranay Shetty, not big. I've done some hard work also.
No, what is your submission regarding?
If a constitutional bench has decided a particular bench was alive to the situation, family structures of the Indian need.
What would be the quantum that has been settled?
As
By
around second to 5 and nothing else. after they have been proliferated, there's some branches have been taking this way, there are some. Lordship, what has, Pranashadi had taken in note of the fact that some judgments were giving 1 lakh. In spite of that, it had decided to scale it down to come. They decided to standardize, because conventional heads of compensation are not meant to be compensation. It's just conventional head, but to, for the
No.
physical aspects of it, not for the financial aspects.
What is your submission
My submission should be,
regarding the question as to whether in a claim under 163A, compensation may be awarded under conventional heads or not?
Yes.
You are conceding? Okay.
But regard at the extent of your lordship, just small. Let it be confined to the wife. I hold that because unless the 5 judge bench itself modifies its own EA. My point is not that 5 judge bench have deliberately taking into consideration the existing norms. Procedure judgment lordship, see, the number of judgments were giving at prior to pronunciation 1 lakh, 3,000. Despite that, even to parents, even to children. But it was not just that. All these judgments were there. Despite that, it was confined to only, it was meant to be conventional, meant to be only sentimentally, not meant to compensate. Conventional heads. Compensation is under lordship and loss of dignity. Should it be allowed to proliferate? It had put a horizontal cap as well as a vertical cap. Vertical cap is 10% after 3 years. So much and 10% after 3 years. There is no scope for horizontal proliferation like other different sector. Giving it to children, sons, brothers, everyone. There's husband, which have given to even brothers and here.
Okay.
This is nice.
Yes. I'm just adding one line also.
And this is the judgment of Supreme Court. I didn't, I mentioned about it. I did not.
Heard.
Is it?
What do you want to say?
Simple line also regarding this Urmila Hadar case. Except Urmila Hadar case, there is nothing to say that this new rule is applicable regarding retrospective effect. Thus, I am submitting that lawsuit. This is the judgment only court has considered the benefit as a beneficial legislation. Court did not interfere.
That you have
Yes,
submitted.
yes. And now lawsuit, even if this judgment was passed, I just submitting that this judgment will be par inquidem. If lawsuit my say insist regarding the retrospectivity, then I will say it is par inquidem because prior to this judgment, there is coordinate based judgment of Supreme Court is there. Now the question will come when two similar judgment of similar bench comes, then the question will be which one will become applicable. Then lordship, my humble submission will be that. Then the question of lordship ratio decided will come. And if you go by the lordship judgment of Urmila Haldar, there is nothing lordship, and the judgment that I relied upon in 2009 judgment, this is a lordship very reasonable was I didn't pass. So this will definitely avoid lordship. So this Urmila Haldar judgment is a pioneer judgment lordship, and the judgment of this Shakti Tubes Limited, it was passed in Long Bank 2009 lawsuit, it still exists, and so it will avail lordship. So his submission regarding the lordship. This is my humble submission.
Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. J. Kalita, learned counsel for respondents / claimants. Hearing concluded, judgment reserved.
Deeply obliged.
Separate file बनव. इथे आता पाठड असे ना. पाठड तो कोण. Yes.
So as regards the plea of contributory negligence being taken now, there is no pleading to that effect.
What was the facts in,
Facts
in
is-
very brief?
Yeah, facts is that out of the total amount awarded because of the death of the husband of the appellant, an amount of rupees 50% was deducted on account of contributory negligence. Lordship may kindly see page 61 and paragraph 19 of the judgment.
Yes, paragraph.
19. As both the, may I read it, Lord?
Yes,
As both the vehicles were involved for the accident, so the OP number 1 is solely responsible for payment of half the total amount of 67,12,000. The OP is found responsible to pay 67,12,000 divided by 2 equals to 33,000, 33
but
lakhs.
apart from para 19, nowhere the aspect of contributory negligence was this.
There, Lordship. Lordship will kindly see then from paragraph 12 of the judge. In fact, from para 10 at page 57.
Yes,
PW2, Prashanta Bora, who was witnessing the occurrence, has deposed that the accident took place when vehicle number so-and-so, Tata Indica car, hit vehicle number so-and-so, Ford Figo. The Ford Figo vehicle fell on a ditch. The driver of the vehicle died on the spot. At that time, he along with other persons brought the injured person, the wife of the victim, who is the appellant now, to the hospital. CW3 Madhurya Sharma, who was working as branch manager of LICI Titawur branch, has deposed that the victim was drawing rupees 74,000 rupees per month as salary. So, Lordship, the income of the deceased person has been proved. During cross-examination, the CW3 has admitted that
no, my query is, apart from para 19, the question regarding contributory, it is there. Oh, okay.
Lordship may see para 12. On the other hand, DW1, Ulok Ranjan Kolita, who was the investigator appointed by the United India Insurance Company Limited, has only stated that the accident took place and the two vehicles were involved. During the time of investigation, he came to know from the MVI report that no damage was caused to the back side of the Ford Figo vehicle. Vehicle was damaged on the right side and in the front side. So the record itself speaks that the deceased himself has driven his vehicle in a rash and negligent manner, for which he lost control of the vehicle and the vehicle fell on the ditch. In cross-examination, EW1 has admitted that he has only presumed that the Indica vehicle was not involved with the accident. That means there is no evidence to show that there has been any contributory negligence on the part of the victim. The Indica, it is immaterial whether the Indica vehicle has hit the front Ford Figo vehicle on the back side or right hand side. The consequence of the accident is that
It fell into ditch.
fell into the ditch. The vehicle was hit, the driver lost control and it fell into a ditch and the driver died. So just because there is little inconsistency, whether it is the right side or the back side, that is immaterial. So on this count, contributory negligence cannot be attributed to the driver of the victim vehicle. That is the point I am trying to make.
Yes.
But Lordship will see the finding of the learned court below. From the above discussion of evidence of PWs, it is found that the opposite party has failed to bring out major contradiction in the evidence of PWs. Because the opposite party has only cross-examined the PW1 on the question of income of the deceased. On the other hand, PW2 is the eyewitness and he has narrated the whole incident vividly. So I do not justify any reason to disbelieve the evidence of PWs. After evaluating the evidence of DW1, it is found that the opposite party has insisted on its claim that the accident took place due to contributory negligence of the victim, though the claimant have claimed that the accident took place due to knocking down by the offending vehicle to the backside of the vehicle driven by the victim. But the MVI report clearly shows that no damage was caused on the backside of the Ford-Figo vehicle. So it is evident from the documents of the police case that the victim was also at fault for driving his vehicle rashly and negligently. Lordship, this finding is wrong, incorrect, because the fact remains that the Ford-Figo vehicle was hit by the Indica vehicle. Whether it is on the back side or it is on the right-hand side, that is immaterial.
No, from where we will come to know that it was hit on the right hand side?
It was from the
Yeah.
charge sheet, Lord.
In the MVA report is there.
Paragraph, annexure 5A, page 50. Lordship will kindly see that is in vernacular. Gauhati is followed Dwara. Lordship will see page 50.
Which line?
It's very small way. Gauhati is followed Dwara. Prosondo Jurere. So গাড়ীখনৰ পিছফালৰ দুৱাৰত লক্ষী প্ৰচণ্ড জোৰেৰে খুন্দা মাৰে.
Yes.
So the fact remains that the Ford-Figo vehicle was hit, and because of which the driver lost control of the vehicle, it fell into a ditch, and the driver died. So no contributory negligence can be attributed on that count. And your lordship will see that the law is that in order to plead contributory negligence, there should be sufficient evidence. I will rely on a very recent judgment of this honorable court. Lordship 2025, Supreme Gauhati 1059. Lordship, in that judgment, in para 7, this honorable court has held. It is the opinion of this court that merely because there being a head-on collision, even in case of head-on collision of two vehicles, the question of contributory negligence would not arise unless any evidence is adduced to that effect that there was some fault on the part of the other vehicle which had resulted in the head-on collision. Lordship, I am giving a copy of the judgment. The relevant portion I have highlighted.
Which para?
Para 7, Lordship. So Lordship turns it will be at the end. At the end, I have highlighted.
Okay.
And your lordship will see, in order to establish contributory negligence, the burden lies on the insurance company that there should be sufficient pleading and sufficient evidence.
Lordship will see their written statement, whether there is any pleading to that effect. Lordship, I have annexed a written statement with the memo of appeal. The relevant portion would be paragraph 20, at page 27, paragraph 8.
Yes.
That the statement made in paragraph 10 of this claimant petition is categorically denied by the opposite party number 1, as because from the admission statement of the claimant himself and from the nature of the alleged accident, it has been crystal clear that the alleged accident was occurred. I am due to rash and negligent driving. The vehicle number so and so, Ford Figo, and the said bicycle. I don't know from where this bicycle came in. This bicycle is not there neither in the charge sheet nor in the DD entry. I don't know where from the insurance company found this. Accordingly, the said bicycle collided with vehicle bearing number so and so Indica. And as such, the opposite party number 3 states that contributory negligence on the part of the motorcycle ridden by the deceased himself is but quite apparent, and the same ought to be taken into consideration while adjudication of the instant petition.
You were not in motorcycle.
There is no, the question of motorcycle being there does not arise at all.
Ah.
This is a figment of their imagination. From where they found the motorcycle, I don't know.
Insurance company has mixed up cases.
Based. WS has been filed in a very perfunctory manner.
You brought bicycle and motorcycle in
But we
a
have,
case where the two cars are involved.
yes, yes. It is happening because copy paste. Well, here is a, we have a file on the additional WS.
The additional W is also nothing is there as regards contributory negligence. Lordship will see. Lordship will see the additional WS which my learned friend has said.
At page,
Para 3,
Page.
31. Para 3, that on investigation by the opposite party number 1 insurance company, it has come to light that 2 vehicles were involved in the alleged accident, and accordingly police had seized vehicle and made 2 seizure list of 2 vehicles bearing numbers Ford Figo so and so Tata Indica, along with MBI report. On such investigation, it has come to light that the vehicle bearing Ford Figo was seized on so and the accident occurred on 1/6/2014. Tata Indica was seized on 13/3/2014. And paragraph 2, the United India Insurance Company Limited has been arranged as opposite party number 1 in the instant capacity of insurers. And Lordship will kindly see paragraph 6. The opposite party number 1 states that as per the terms and conditions of the policy in respect of vehicle bearing number so, that is a different vehicle has come in, Lordship. A tracker AS01 AC 6404. I don't know where this tracker came in now. The insurance company is not liable to pay compensation to the claimant, if any awarded by this tribunal. In this case, as a driver of the said vehicle, he did not have a driving license to drive a bus. Now, where from this bus comes from?
Mr. Paul, you have
Case has been conducted in a rather brilliant manner, Lordship.
I have not conducted till now.
I don't know.
My learned senior friend is conducting last 3 days. I have not started even then I have opened my leaf also.
Whatever you feel like, I am arguing.
Well, this type of word should not be used. Should not be used. You are facing that trial, you are facing your argument. I am also facing that. I have not opened my.
yes, conclude.
Lordship kindly see, hence the instant claim petition may be dismissed against the opposite party number 1. Lordship, these are their pleadings. And on the basis of these pleadings, in the absence of any evidence, how come a conclusion can be drawn that the victim was that contributory negligence can be attributed to the victim so as to entitle the learned tribunal below to deduct 50% from the awarded amount of compensation.
Okay. You were, while accident occurred, you were driving Ford Figo.
Fourth,
The deceased was driving Ford Figo.
and it was hit by a Tata Indica.
Yes.
The lordship is.
And Tata Indica is insured by the
Yes.
respondent.
My father.
Okay. Yes.
The other judgments also on that point, lordship, on contributory negligence.
Oh, this much is enough.
How to prove contributory negligence.
No, your plea is that the respondent side has neither pleaded nor laid any evidence to prove contributory
In
negligence.
the absence of that, was not proper on the part of the learned tribunal.
And tribunal, without discussing the fact of contributory negligence, in para 19 directly deducted
Yes.
the amount only because two vehicles were involved. Yes, Mr. Paul.
Madam, kindly see this memo of appeal. My learned friend has accompanied all the documents, but he has not accompanied the cross-examination. This is very interesting. This is a suppression of material fact. If I go through the cross-examination, it is very clear. What is the cross-examination? What is stated PW 1, 2? One is the claimant herself. She was also was traveling along with her husband. So I have the difficulty to read it. My colleague is.
No, what you want to say?
Alright, I have somehow managed. If I start, claimant. Alright, we will read it.
No, his submission is that the tribunal.
I'm coming, my lord. I'm coming.
Yes, you answer.
To the list.
Yes.
দুৰ্ঘটনাৰ সময়তে PW1 claimant.
Yes.
Cross examination. দুৰ্ঘটনাৰ সময়তে আমি গাড়ী চলাই আছিল আৰু তো গাড়ীটো মই বহি আছিলো। আমি প্ৰায় 80 কিলোমিটাৰ বেগত গাড়ী চলাইছিলে। কামটো 80 কিলোমিটাৰ 80 kilometer speed was there. It is an admitted fact because she was along with her deceased husband. Very important. 80 kilometers, if the figure running or flying 80 kilometers, whether he is lost control or something, then what will happen if Salai Asil? So far I understood. দুৰ্ঘটনাটোত মই গাড়ী মানে that is মই আৰু বেলেগ গাড়ী কিমান আছিল মই ক'ব নোৱাৰো বেলেগ গাড়ীটো কিমান স্পীডত আছে মই ক'ব নোৱাৰো নেক্সট যান বাহনৰ পৰিদৰ্শনে কি প্ৰতিবেদন দিছিল মই নাজানো he has exhibited all the document police document criminal documents but she cannot say anything. This is the thing very important. First two lines. Others, I'm not going. Now the question is PW2 eyewitness. What he has stated. In the chief written, para number 2. If I read it, so far,
yes.
My notes. 1/6/2014 at about 1 p.m. I was coming from Dibrugarh while reached at Dikhanj.
Who is PW2?
PW the eyewitness, my lord.
Madhurya Sharma. What is his name?
No. Prasanto Burua. Well, I flag mark 4. I mark it.
Yes.
May I
Yes.
call it? Yes. Para number 2, important. and while reach near so and so bridge and vehicle number so and so it Atlantica hit the vehicle fraud, which which was coming ahead of us from backside. As a result, ahead. That means fraud was coming and both the vehicle possibly presumption is going ahead. He has seen. Now this is the paragraph 2. Now the cross-examination. Well, kindly can see the backside is the cross-examination. Yes.
I have to
Lateral-
go.
Mala-
This bench has to rise.
So,
I'll go for a DB matter. I'll come back and continue with this case.
Mala-
Other cases may have to be adjourned. We may not have time for other cases. Only this case I will take up again. There, it may not take more than 15 to 20 minutes. I'll come back.
Mala-
Other matters you take dates from court master. Court master will provide date according to our board.